There's one other attorney on this case right now. Mark Donnelly probably is.
Oh, okay.
Oh, I'm sorry.
Hold on.
That's right. He came in
Mark
late.
Donnelly. All right.
Yes, sir.
I see
Your
him.
Honor.
Okay, it looks like we've got a connection with Mr. Donnelly. Can you hear me, sir?
Yes, good morning, Your Honor. I'm having some technical difficulties, so I don't have video available. I'm sorry.
All right, that's fine. We can hear you. All right, Shannon, you can put us on the record now.
Okay, go ahead.
This is a matter of Roehrig and McCabe versus MDOC et al. Mr. Markle for the plaintiff, Mr. Asbenson, and Mr. Donnelly for the defendants. And I believe this is defendants, well, plaintiff's motion in limine, correct?
That's correct, Your Honor.
Go ahead, Mr. Markle.
Thank you, Your Honor. Judge, this is a employment case. It is not a race case. There has never been an allegation of any racial discrimination. This is a retaliation case that centers around plaintiffs who engaged in protected activity, and they allege that they were terminated as a result. The termination at issue and the relevant time periods in this case is they were terminated on May 3rd, 2017. Both Vicky McCabe and Brent Roehrig, both plaintiffs, were terminated on that date. There is no allegation that Miss McCabe ever did anything racist in her whole life. As you know, this motion centers on text messages that were admittedly sent and admittedly horrible. I'll be the first one to say it, and I said it in my brief, that surfaced after we filed this case, that were sent after work hours, outside of work, to another coworker in September of 2015. We aren't alleging anything that led to the termination in 2015, which is important. Mr. Roehrig admits he sent these horrible messages. They're disgusting. They're incredibly offensive to me, and I'm sure everyone else here. No question about it. But the question for you, and that it's an extremely important one, is whether these should be allowed to be presented to the jury. And it's clear that the defense in this case has not centered around the 2017 termination, but is centered around these text messages that were sent years earlier outside of work. It's clear because Mr.
But let me stop you. My understanding from the response is that these did factor in the decision to terminate Mr. Roehrig because of the progressive discipline approach that the defendant uses.
Yes.
If these indeed were factors in a later decision, even though the activity that prompted the latest investigation and decision was something that happened later, but this was still a part of that. Like
absolutely,
perhaps
Judge.
if he didn't have this prior discipline on his record, he may have been suspended. He may have received some lesser penalty, but received the equivalent of the death penalty in employment law as a result of the prior events that led to the prior discipline.
Yeah, Judge, let me address that. So we are not seeking to exclude the fact that Mr. Roehrig committed misconduct in 2015. We're not seeking to exclude the fact that he committed serious misconduct. We're not seeking to exclude the fact that he was suspended for 15 days. We're not seeking to exclude any of that. The department should be able to tell the jury that Mr. Roehrig had previous discipline in 2015 and that factored into their decision. Although we disagree with that. If you look at Miss McCabe Your Honor. Ms. McCabe was terminated along with Mr. Warrig. Ms. McCabe is an innocent. There's no allegation she did anything wrong in her history at all whatsoever, let alone any racial things. There's I think a isolated incident of discipline in her history, and she was terminated along with Mr. Warrig. So the fact that these individuals may have had a disciplinary history is relevant. The fact that the specific circumstances of that discipline is not relevant. And even if it were marginally relevant, it would be more prejudicial than probative. The department's problem is Ms. McCabe got the axe along with Mr. Warrig. She didn't do anything. She didn't send racial messages after work, and she still got the axe. So if you let me tell you the evidentiary bases for this, my suggestion would be they can tell the jury Mr. Warrig admittedly committed misconduct in 2015. It was serious misconduct. He was suspended for 15 days, and they can argue to the jury that that factored in. But the substance of that misconduct would be extremely prejudicial. It's not relevant or minimally relevant, and it's character evidence. So, and let me cite you the case law discussing these, Judge. Mr. S. Benson can't cite a single case. The closest that the department cites one case on this issue, and it's the Pena case, or Pena, and that's as close as they can get. I've cited to you a whole body of case law addressing with this issue. We were not able to find Michigan law directly on point, but I've cited Michigan law analyzes federal law as it relates to the Elliott-Larsen Civil Rights Act, and I've cited you the law on this. So my first position on why this is should be kept out is the substance of what happened is not relevant under 401. Certainly the fact he was disciplined is relevant, no problem. We're not seeking to exclude that, but the actual substance of the text messages is not relevant. These text messages were sent after hours. They were horrible, but they were sent by Mr. Warrig after hours in response to a coworker propositioning his wife. If you look at the Pena case, which is what the defendants rely on, they analyzed relevance in the context of offensive comments made by a plaintiff. One thing that they noticed is they specifically quoted on page 7, quote, "What must be focused on, however, is a plaintiff's conduct at work, not his conduct outside of work." That's a quote. They're citing Burns versus McGregor. That's a 8th Circuit case. Also, in Pena, the trial court excluded the plaintiff calling his supervisor a, quote, fat F-U-C-K, and the Court of Appeals upheld that decision. Pena was a racial harassment case. So in Pena, you had a Hispanic American who claims that he was subjected to constant racial harassment at work. And the court said that maybe plaintiffs' comments about race could be relevant in that context, but the fact that he called his supervisor a fat F word was not relevant because it didn't have any bearing on things that were relevant to the case. This is not a racial harassment case. We're not alleging that Mr. Warrig was subjected to racial harassment at work. We're not alleging it at all. There is no racial component to this case. It's a protected activity case. So the department still has failed to articulate any basis that would allow the substance of these conversations to come in. I think more importantly, and most importantly, is it's more prejudicial than probative. Judge, these are so offensive, and they're so disgusting and offensive that for that very reason, they have to be excluded under 403 and under 404B, especially the character evidence rule, especially when you don't have a strong relevant basis to allow these in. In the federal case, the EOC versus Holmes, the court citing the 10th Circuit, sums up why this is so offensive. They said courts around the country, including the 10th Circuit, have repeatedly held that far more than a mere offensive utterance, the word N-word is pure anathema to African Americans. It says no single act could be more offensive. And then they go on to say this word is perhaps the most offensive and inflammatory racial slur in English, a word expressive of racial hatred and bigotry. Judge, this is so offensive that yesterday we were supposed to facilitate this case with a facilitator who was African American. And he called me and he said, Mr. Marco, I respect you greatly. I want to help get this case done, but due to these text messages, I don't think I'm in a position where I can facilitate this case. And this is an experienced lawyer who has about double or triple the experience I have in the field. He's well respected. And this gentleman honestly and candidly called us and said that he could not facilitate this case because of those words. And that goes to why under 403, these need to be kept out. And I've cited you a wealth of case law on this. Beverly versus Desmond. In Beverly versus Desmond, this is a federal case. There was significant racial slurs, including, quote, "We kill the Muslim in my country now." The N-word was used. The quote, "Slavery has been over," referring to the Beverly as an N-word. And we don't want N-words on the patio. Horrible, horrible things that were said. But the court said in that particular case, there was not a relevant thread that could allow that in because that was an age discrimination case. That was an age discrimination case, similar to how this is not a race discrimination case. In EOC versus Holmes, the plaintiff used the N-word and the court said that was not relevant because the conduct, and this is a quote, "The plaintiff's conduct outside of work is not a relevant factor that could eliminate their legal protections against unwelcome harassment at work." And that was a racial harassment case, Judge, in Holmes. A racial harassment. The plaintiffs in that case were African Americans who said that they were being discriminated against. And the court said that conduct outside of work is not relevant enough that could allow those words to come in. I've also cited you Gonzalez versus Olson, which is a police misconduct case where the officer who shot the plaintiff said, quote, "I'm going to get you, N-word," before he shot him. And the court ruled that it was more prejudicial than probative because, and this is important, because the plaintiff did not allege that it was racially motivated. And we're not alleging in this case that there's any racial motivations. I cited you cases. For some reason, Florida has a lot of these cases. We've searched all over the country. Lorena Farm versus Lopez, where the plaintiff called the Cubans, quote, "scum." They found that was reversible error to allow that in because it was more prejudicial than probative. And MCI Express versus Ford Motor Company, where the plaintiff referred to them as quote, "goddamn Cubans," they were granted a new trial. Judge, if you remember the O.J. Simpson case and the rulings that were made, a similar issue came up in that case involving Mark Furman. Mark Furman was the officer who found critical evidence against Mr. Simpson and who had testified on the stand under oath early in the trial that he had never called somebody the N-word. Later in that trial, the dream team for Mr. Simpson discovered undercover tapes of Mr. Furman where he used the N-word. I think it was like 70 times or some ridiculous amount of times. And Judge Ito, there was a motion, and Judge Ito recognized in that case, even though there was a relevant use for this evidence, you have a police officer who's accused of framing O.J. Simpson, who lies on the stand. even though there was an extremely relevant use being impeachment and there was racially motivated fabrication of evidence, that was the defense, that this was racially motivated. Even Judge Ito, in that case, ruled that this is so offensive that if this comes in, it would inject so much prejudice into the process, it would make it impossible to have a fair jury. And I submit to you, Judge, in this case, where we don't have any relevant threads except the fact that he was disciplined, which we're not disputing and which should get in, this would inject irreversible prejudice. This case would be over, because as we can see how offensive it is to everybody here, as we can see how the facilitator, who's an experienced lawyer, who's very well respected, who I consider a friend, could not do this case, who I have other cases with. How could we expect a jury to come in and set aside that conduct? It just can't be done. It just can't be done. And I know that in these situations, it's easy to say, well, the plaintiff did it, it's horrible, and he needs to lie with it. But the evidentiary rules are set up to try cases, not people. And I would also ask this court to consider the practical implications for Miss McCabe, Your Honor. Miss McCabe, there's no allegation she did anything, even the slightest bit racial. I think even Mr. S. Benson will admit she's a good lady. She has a good heart. She never did anything that would lead the department to think that she's a bad person in any way or did anything to slight any minorities. If you allow this evidence in, it will completely taint Miss McCabe's case, because the jury's going to consider that in the context, and it will be extremely prejudicial to her case as well.
I would think it would make Ms. McCabe's case stronger, frankly.
Judge,
if they were both terminated for the same reason, he had this horrible background, she didn't. That might even make her case stronger, couldn't it?
Judge, I think that, anything will depends on the jury that you get. There could be different views on that. My view is, if this evidence comes in, it's a death blow for both the plaintiffs. And this is going to become a central focus of the trial, when it's not why they terminated her. If you look at Mr. S. Benson, will have to admit to you that although the fact that he was disciplined in the past may have been a aggravating circumstance, nobody said in this case that Mr. Rohrig was racist again, and that's why he was terminated. This was not an allegation that he was a repeat racist, and that's why he was terminated, Your Honor. Remember, the allegation for termination is not that Mr. Rohrig did anything racial. It's that he did not adequately respond to a FOIA request, and that he had not put emails in a FOIA request, and that because he withheld those emails, then he was terminated. Ms. McCabe, again, no racial history. So under 404B, this trial is going to be about, and you can see it from Mr. S. Benson's pleading, and I don't blame him. I mean, this is a horrible thing. And so he's chomping at the bit to put this in and to make this front and center, just like he did in his facilitation summary to the facilitator, just like he's done on his previous motion pleadings with this court. It's character evidence. And as Justice Kavanaugh said in People versus Crawford, as the trial court, you need to be especially sensitive and on guard against attempts to get in character evidence masquerading as relevant evidence. And that's what this is. I mean, there's no question that they can tell the jury, Judge, about Mr. Rohrig.
Mr. Markle, I understand your arguments, and I hate to cut you shorter. I've got a full docket this morning. I need to hear from Mr. Asbenson or Mr. Donnelly, whoever it is that's going to be presenting the counter argument.
I'll be taking that, Your Honor. Mr. Donnelly can add anything that he wants. But, Your Honor, John misquotes Rule 403, and he misquoted it in his brief. I think all judges know it, but I'm just going to go ahead and go through it again. Although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. This isn't unfair prejudice. This is conduct that Mr. Rohrig engaged in. This is conduct that was considered as part of his termination. Mr. Marco, I can understand, evidently he didn't vet the case well enough and this came up after the fact for him, but this is something that was on Mr. Rohrig's work history at the time that he was terminated. It was something he knew about. It was something he had already.
And pardon me, but was Ms. McCabe terminated for the identical reason that Mr. Rohrig was?
She was terminated for a similar reason, Your Honor. I mean, they're not identical, but it's both of them were responding to a FOIA request that was submitted by an African American to
the same FOIA request.
Yep, the same FOIA request. Ms.
And
McCabe,
they were both terminated for not responding fully to that FOIA request.
that is correct, and that was a FOIA request that was.
So if it was sufficient to terminate Ms. McCabe, how much of a factor could the prior discipline have been as to Mr. Rohrig?
Your Honor, Mr. Rohrig had a 15-day discipline on his record. If all that he did, any additional discipline would justify the termination after that significant of a discipline. And so the jury needs to be able to know exactly why this was so significant for him. I agree that there's going to be a factual dispute, and it very well could go to the jury, where the jury's going to decide between Vicky McCabe and Brent Rohrig. Vicky McCabe shouldn't have been terminated. Brent Rohrig should have. The jury can make that determination based on whatever they want, based on the facts that get presented. But if we protect the plaintiff from actually having the jury see what he did, what conduct we were looking at when we terminated him, the jury cannot make a fair decision about whether he was fairly terminated. And the same for Vicky McCabe. They need to have the facts to be able to determine whether or not we correctly terminated Mr. Rohrig or Ms. McCabe. These facts must come in so that the jury can make that kind of determination. To do anything less than that, to put in anything less than what he actually did, would be holding MDOC accountable for things would be asking the jury to pass judgment on MDOC's conduct without giving them all of the information that MDOC had. Mr. Marco says that this is extremely prejudicial, but again, Your Honor, he leaves out the fact that it has to be unfairly prejudicial, and this is not unfairly prejudicial. Mr. Marco cites a great wealth of cases from foreign jurisdictions, most of which aren't even published in those foreign jurisdictions. And in none of those cases is the plaintiff the one who has discipline on their record at the time that they're terminated or whatever the case may be. I mean, some of these cases that he cites are slip and fall cases. And Your Honor, in slip and fall cases, the N-word shouldn't be coming in. It's a slip and fall case. Some of them are contract cases. It doesn't matter if someone thought, terminated the contract or breached the contract because of their racial prejudice. It just matters that they breached the contract. Mr. Marco is citing all of these cases, but none of them even come close to the facts of this case, where on his discipline at the time of the termination is a discipline for sending these racist text messages where the N-word is used 11 times to a coworker. And then, Your Honor, the facts in the timeline demonstrate a pattern and practice with Mr. Rohrig. In June of 2015, Mr. Rohrig is reported because he sends an African subordinate basically on a snipe hunt. He sends him to go find this report that doesn't exist. And Ms. Artis finds that, Ms. Artis, the deputy warden, finds that racist. And so she reports that. And what does Mr. Rohrig do? He immediately files a complaint against her as soon as he finds out about it. because he doesn't want his racism exposed. Then Ms. Artis is the same one who received the messages. They're delivered to her by this African American who received these horribly racist text messages. They're delivered to her. And what does Mr. Warrig do? Mr. Warrig, as much as Mr. Marco doesn't want this case to be about race, Mr. Warrig files a complaint with the EEOC after he gets disciplined for these racist text messages, claiming that he was the subject, or he experienced racial discrimination because he sent those text messages and because of the discipline he received for those text messages. He claims that was racist. Now, this case has two counts. The first one is a First Amendment retaliation claim. The second one is a retaliation claim under ELPRA. The only protected conduct that Mr. Warrig engaged in was sending that EEOC complaint where he claims that he was discriminated on the basis of race. Race is absolutely central to this case. Additionally,
all right, counsel, I'm going to limit argument at this point. I'm ready to rule. Mr. Marco, I understand that this is horribly prejudicial to your client, but the reality is it unfairly prejudicial? He's the one that uttered the words. He's the one that was disciplined for uttering the words, and his discipline was indeed a factor in the decision, or at least it's being alleged to be a factor in the department's decision to terminate. I don't think I can keep this out. I think it's got to come in. So I'm going to deny your motion. Mr. Aspenson, you'll prepare an order,
yes,
in order to that effect. Thank you.
Your Honor, my motion regarding the Director Washington deposition.
So there's two motions up. I just saw motion to exclude racist messages. What? I don't even see the other one on the docket, unless it's buried down here. Are you prepared to argue that today? I've not reviewed it ahead of time. It's not on my docket. There's only one motion on the docket.
John,
what's your pleasure, gentlemen?
Yeah, Judge, it's just a motion to stay. I mean, it's like a one-page motion to stay.
Oh, okay. I did see that in the file, but I didn't see it on the docket. So as soon as I realized it wasn't on the docket, I just assumed it was noticed up for a later date.
I apologize for that mix-up, Your Honor. John, if you're okay.
If you're both prepared for me to address it, I'll do it, but please move quickly. I got a lot of stuff this morning.
Absolutely, Your Honor. Defense has filed an interlocutory appeal regarding the order to compel Director Washington's deposition testimony. And we ask that your order compelling her deposition be stayed until there is a ruling on the application for leave to appeal.
And Mr. Marco?
Judge, we oppose. There's no case in the country that held that the Apex deposition rule applies to someone who has direct involvement in a termination decision.
And Your Honor, briefly,
and I understand you've already argued that. The issue is now, did I make the correct call? That's in the Court of Appeals lap. I'm going to deny the motion to stay. You can file your motion with the Court of Appeals. Mr. Marco, you present that order, please.
Thank you, Your Honor.
Okay, thank you, Judge.
Thank you.
Have a good day.
Have a good day, gentlemen.
Thank you.
Looks like Mr. Beer has left the building.
Good morning, Your
There
Honor.
he is. Good morning. We don't have an audio connection with him yet. Okay, this is a matter of Great Lakes Home Health versus Ewing et al. Gentlemen, are you expecting anyone else to participate this morning?
Yeah, Your Honor, we had Mr. Porter in my office, who should be in the waiting room, was going to argue the motions to compel, and I'm here to argue the protective order motion.
All right, that's David Porter.
Yes.
Your Honor,
Anyone else? Any parties?
yes, Your Honor. Actually, Mr. Pelton and I are in a similar scenario. I'm here to observe. Somewhere Richard Lindsay should be on this call. He's planning to argue the motion to compel.
All right, hold on, let me look for him.
I have unfortunately, a deposition starting in about 20 minutes here, and so I'm probably going to have to duck off at some point before that hears. I'm going to walk
All
in.
right,
There he is.
I brought Mr. Lindsay in, but
Sideways.
he's sideways. There he is.
There you go. He looks better.
Okay, Great Lakes Home Health versus Ewing. Apparently there's two motions up this morning, a motion to compel and a motion for a protective order. Any preferences to which one I hear first?
Well,
Your Honor, there's
the
actually
protect-
one, we have a motion as well
Oh, okay.
about.
Oh, I see
expert
that.
witnesses.
Enforcing court order and extending dates. Okay. Well, again, I'll hear all three. Which order would you prefer to go in? Does it matter to anyone?
Well, the protective order motion was brought by counsel for the deponent, Mrs. Deary. I don't see that he's on. That was going to be Kevin O'Shea.
I actually
Oh,
think
well, I was asking if there was anybody else that should be here. What's that name?
O'Shea.
Mr. O'Shea, I see him. Let's bring him in. Is there anyone else that should be in here? Speak now or forever hold your peace. Mr. O'Shea, good morning. Is there someone else not present who you are expecting to participate this morning? I got a real full waiting room and I can't tell who's here for which case if you don't tell me.
No, Your Honor, just me.
Okay, here we go. Now, which one do you want to hear first for the third time?
Your Honor, ours is quite short. I'd be glad to go ahead with that to get that out of the way.
All right, you win, Mr. Lindsay. Go ahead.
All right. Again, appearing on behalf of defendants, we filed a motion to amend our witness list to add 2 expert witnesses. One of them would testify potentially about home care, home base, which was discussed at length in the filings by the parties, but essentially is a program used by Great Lakes and is now used by Caroline. And there's some allegations about how that's been used by Caroline and whether that's had any impact from anything that Casey Stump brought or did while she was at Great Lakes before. We had listed, that as a to be named expert and had not identified anybody. We talked to plaintiffs about the idea of extending discovery just to allow us to file this list and just to allow depositions relative to that. And it got caught up in all these other motions that are in front of the court. So we just wanted to make sure this was in front of the court. And then the other one is the other issue, as the court reviewed, hopefully those documents that I provided yesterday under seal regarding clinical guides. This would be a former quality director at Oakland Hospital that would talk about these types of guides, what they're used for, how they're developed, those types of things. And again, we were willing to agree to a limited extension of discovery for those issues to be covered.
So first of all, is the motion to amend the expert witness list opposed?
Your Honor, we have no objection to granting an extension for them to amend their witness list, so long as we are granted the same courtesy of extending the fact discovery so that we can complete our portion of discovery. That's been our position with the defendants this entire time. It's pretty simple. Like things should be treated alike. So if they're going to get an extension, we should as well. It's all been caused by the same thing, which is defendant's delay in producing and naming witnesses.
So Mr. Lindsay, your motion's granted, and I will grant whatever extension is needed in order to allow discovery on this issue. And I'm assuming, Mr. Porter, you would want the opportunity to name an expert to address whatever area of expertise that Mr. Lindsay has added.
Yes, Your Honor. Yes.
I will grant that. I don't know when we're going to be doing trials anyway, so I don't have a problem with extending dates.
Thank you, Your Honor.
How much additional time do you think you'll need?
Your Honor, we've requested. Go ahead, Mr. Lindsay.
Are we talking about the expert witnesses, Your Honor?
Unless there's an extension being requested for something else.
I'm only requesting as to experts. We will file our list today. We've got the names, and then I think probably 30 days to get those things resolved should be sufficient.
Judge, let me be clear. Our motion, the first motion that was filed in this series of motions was a motion to extend the dates of fact discovery and all related pretrial dates. Defendants opposed that request and then came back and tried to extend the one date that applied, that benefited them. Our position this entire time has been, let's just extend all the dates because they've all been pushed back or should be pushed back for the same reason, which is the defendant's delay in producing documents and forcing us to take fact discovery within the span of a week at the end of discovery. If defendants want the additional time.
How much additional time do you need, Mr. Porter?
We've asked for 60 days, which should not upset any of the other remaining dates in the scheduling order because none of them have been set. As you said, jury trials are not likely to be conducted.
I'm going to grant that motion, and it includes fact and expert witness discovery.
Thank you, Your Honor.
All right. Mr. Lindsay, you mentioned these documents that were submitted under seal. I just want to make sure there's compliance with the court rule. I think we have to notify the Supreme Court when does anybody know the rule off the top of their head?
8 point.
I don't, Your Honor.
In Chapter 8.
We had an order that was entered, and I was following that, and I did not even refer to the court rule. So
I think there's another step we have to take. I'm aware of the rule, but I don't deal with it often enough to remember precisely what it says. It absolutely has to be complied with. I don't have the ability to waive compliance with that order.
Judge, just to be clear, I don't believe Mr. Lindsay is submitting it to be filed with the court. We referenced it in our latest emergency motion and we said that we would submit it for an in-camera inspection if the court would like. And Mr. Lindsay was nice enough to put it in a sealed envelope and transmit it to the court for your convenience.
I got you. So you're not asking that it be filed, just that there be an in-camera inspection of it?
Correct, Your Honor. Correct.
Okay. Yeah. I think we're okay. Then. Like I said, I just want to make sure that this, when documents are filed under seal, that rule has to be complied with. In-camera inspection, my understanding is the rule doesn't apply.
Correct.
Your Honor, can I raise another issue? Sorry, go ahead.
Am I being asked to do that in-camera inspection now?
If you think it is relevant, the purpose of bring it to your attention is because they were just recently produced just 2 days ago, and they confirm the defendant's significant breaches of their restrictive covenants with our client. We have requested these documents almost a year ago, and they just showed up 2 days ago on the eve of the discovery deadline. Now, it almost becomes a moot point at this point because you have already granted our extension. We submitted it to the court just in case the court was having any other troubles ruling on our motion for an extension of dates. This, I think, cinches it and shows that this latest production demonstrates the need for additional discovery. And we will do that with the extension.
But hold on a minute.
Yep.
Go ahead, Mr. Beer.
Your Honor, I think it's pretty clear where this is headed. And so if you've already granted Mr. Porter's motion to extend fact-based discovery for 60 days, My suggestion would be that we just also do the expert witnesses for 60 days. Much of those in-camera documents were submitted by Mr. Porter for purposes of arguing for an additional 60 days, which it sounds like he's already got. My feeling is, at this point, it probably makes sense for the parties, having heard what you've said, to just agree to extend all discovery in this case for 60 days and to move past a lot of these issues. I mean, candidly, I disagree with much of what Mr. Porter just said, but I don't know that we need to spend a lot of time on it, because arguing those issues, we can do another day. It sounds like we're going to be doing 60 more days of discovery in this case. So at that point, I guess I don't think it much matters about the in-camera documents.
So the motion to compel looks like whatever you were seeking to compel has now been produced. Is that correct?
That's correct.
So that's resolved. I've already told you I'm fine with the extension. Like I said, I don't know when we're going to be able to do trials with full courtrooms. I don't think it's too far away, but I'm not going to guess wrong. So I'm just going to tell you I don't know. How's that? Is there anything else that I really need to address this morning, then?
Your Honor, I just want to raise one other question. In their motion, they had requested opportunity to take additional depositions, and they have taken, just for instance, have taken corporate deposition, corporate representative depositions. They've taken Carolyn Ewing and Casey Stump like 5 hours out of the 7 hours, and they're asking for a full another full additional day. We would object to that. They've had plenty of time to review, to ask lots and lots and lots of questions, and don't see any reason for them to be allowed any additional time. Certainly they would be, allowed to finish those depositions and take other corporate deps that hadn't been taken yet. And obviously other fact witnesses that they have not taken depositions yet.
Judge, the depositions taken so far have not been fruitful because we did not have the documents needed in order to depose them. They just showed up recently. Sometimes, in one case, it was after the deposition itself. So yes, we do need additional time to retake their depositions. We may not need a full 7 hours, given that we've got a couple hours left on the initial depositions, but we should not be hamstrung by just the first initial 7 hours, given the defendant's delay in producing all these highly relevant and critical documents. So we would reiterate our request.
I'm not going to do anything to limit redeposing of anyone or continuing depositions, other than to say, I don't want you to ask the same questions over again, unless you got an answer the first time around that's contradicted by the documents that you've now received. You absolutely can inquire into those issues, but I don't want you to waste a lot of time covering the same material. I can't really put that in an order. I can simply tell you, if that happens, I wouldn't be surprised to receive an emergency motion or phone call to say, Judge, this is just getting out of hand. And I would be receptive to that. So just use your judgment in that respect.
Your Honor, I think that would be fine. I just want to reiterate, because of what Mr. Porter said, we provided these documents, and then they took Carolyn Ewing's corporate dep for Care Evolution yesterday. Mr. Beer was actually in that, so I'll let him address it. But my understanding is they spent a couple hours talking about this, and I just don't know, at some point, how many times you need to ask a question. So I think what you said, we understood, and we will call you if there's an issue.
I think that's fair. I mean, that's my concern, is that in this case, for instance, Carolyn Ewing has been in depositions now for over 10 hours, including a full day yesterday, where these documents were frankly entered as exhibits, including the ones that were given to you in camera today. So I'm fine, though, as long as I can take the position in these depositions that we're not going to sit through, because I have some witnesses that are being deposed between this and other cases 3, 4, 5, 6 times. So I just don't want to answer the same questions, 15 times.
It appears that a lot of time is being invested in the litigation itself. Has any thought or time been invested in exploring a resolution?
Yes, we did. And we were in the midst of that when the defendants decided that they no longer wanted to pursue resolution and reinitiated the case by filing a motion to compel, which then initiated this sort of sprint to the end of discovery, unbeknownst to us. So yes, there was an attempt, but that attempt fell through.
Quickly, Your Honor, Mr. Porter wasn't involved in the case at that time, so I'll forgive him for completely misrepresenting what occurred at that time. He's new to the case, wasn't involved in the conversations, so him misrepresenting himself is, I guess, acceptable at this point. You emailed her.
Gentlemen, I don't need to hear this. Hear me. You're spending a lot of time on litigation expenses. Could some of that be invested in resolution? It's a simple question. Let's call it a rhetorical question. I don't need an answer. I just want you to think about it, okay?
Yes, Your Honor.
All right.
Thank you, Your Honor.
Anything else that the court has to address this morning?
Your Honor, Kevin O'Shea on behalf of non-party Sherry Lynn Deary. We filed a motion for protective order to narrow the scope of Ms. Deary's deposition and a document subpoena we received from the plaintiffs. Her deposition is scheduled to take place next week. We've asked the court to issue an order similar to the order Judge Warren issued in an Oakland County case for Ms. Deary's prior deposition to limit it only to the claims alleged in the complaint. My understanding, based on the response brief that the plaintiffs filed, is that they don't have an objection to such a limitation because they only intend to ask relevant questions anyway. So it appears to me we have an agreement on that. If I'm wrong, Mr. Pelton can jump in.
I don't think, and good morning, Mr. O'Shea. It's good to see you.
Nice to see you, Eric.
Our position is the civil rules of procedure provide what happens in deposition. Relevance objections are preserved. They're not waived under the court rules. If they feel we've gone way beyond and out of bounds and we're harassing the deponent, then there's a process for that. But she is quite involved in this case. She has connections with all. So Care Evolutions is the company that was started by another defendant, Ms. Ewing. And all three of the customers or clients of Care Evolutions had ties to Mrs. Deary, either as a board member or an owner. And we now, as of 2 days ago, have a series of emails that tie her into various solicitations and work that they obtain, perhaps in violation of certain restrictive covenants. She's deeply into this, and our position is that each of the document requests are relevant. It sounds like she has information that should be produced, and will live by the court rules. But to put an artificial limit on it of relevance, you're into the same argument. So that's already in the court rule, preserved. There's no reason to have a court order on it in advance.
Well, Your Honor, we're suggesting this because Judge Warren thought it was a good idea, and it worked out great because Ms. Deary's deposition in the Oakland County case went forward last month without incident, and we'd like that to happen again this time. Of course, this is against the background of the fact that Ms. Deary has been a target of plaintiffs for some time, and although Mr. Pelton says she's deeply involved in this case, she's not even mentioned in the complaint, and nor are the entities that are subject of the document requests. We will respond to document requests we haven't objected to, Your Honor, but there are specific requests that are clearly overbroad that are attempting to get information about Ms. Deary that has nothing to do with the claims raised in the complaint. And we'd like to get an order limiting requests 2, 5, 7, 8, and 9, as well as an order similar to Judge Warren's, so that we can make sure the deposition goes forward without incident as her last one did in April.
I am simply going to direct that you follow the court rules. If you see during the course of the deposition that they are fishing and asking questions far beyond what seeking information that would be relevant in this case, you may instruct your witness not to answer the question, and I'll deal with that at a future date.
Thank you, Your Honor. With regard to the document requests, as I said, we'd like to get limitations on the ones that are listed specifically in our brief that we believe are clearly overbroad and aren't related to the claims in the case.
Can I have a response to that?
Yeah, well, the ones he's highlighted. So number 2 asks for any documents that were disseminated. These would be plaintiff's documents that were disseminated for the benefit of the various defendants in the case, and Ms. Deary, who again has ties to each of these companies. And we have at least one document that came in 2 days ago that's marked, in fact, it's the one you got under seal that was talked about earlier, but it's a clinical guide that defendant Ewing sent to Mrs. Deary. So it suggests she was receiving confidential information of Alera's, and we'd like to know about that if she has any. We think it's quite relevant to this case. If she doesn't have any, then she doesn't, but it's directly tied to the various defendants.
Your Honor, that's not the case. If you look at request number 2, it says documents by or for the benefit of Sherry Lynn Deary.
Hold on. Let me find it. I want to look at it as you're describing it. All right. And this was attached to your motion, Mr. O'Shea?
Yes, it's also in the text of the motion, Your Honor, at page 9 on our, the brief, excuse me.
All right. Let me get there. Which particular bullet were you directing my attention to?
The first one, Your Honor, Mr. Pelton, in describing this, said that they were asking for documents regarding defendants, but they're not, Your Honor. As you can see, the request is for documents by or for the benefit of Sherry Lynn Deary, and my client is not a party. She's not mentioned in the complaint.
Well, wait a minute.
These are not limited to documents related to the defendants. If Mr. Pelton wants to make that limitation, then we wouldn't have an objection to this. That's the problem.
Well, but wait a minute. Mr. O'Shea's brief does not, in that first bullet, doesn't state the whole document request. It stops at Mrs. Deary, and it goes on to mention each of the defendants. So it is tied in. That's not what the subpoena says, what they've quoted. So we need to look at I think Your Honor needs to look at the subpoena, not what they've selectively quoted.
And the subpoena is where? Do I have that?
Yeah, the subpoena is attached to our brief, Your Honor. I agree with Mr. Pelton. He's asked, in addition to the documents about Ms. Deary, he's asked for documents about the defendants. We're not objecting to that portion of request number 2. We're objecting to the portion that's limited simply to Ms. Deary. To the extent she has documents that are related to the defendants, we will produce those. Or excuse me, the plaintiffs.
So the part that's in the subpoena that's not quoted in your bullet, you don't have an objection to. Your
That's right.
objection is simply to documents by or for the benefit of Sherry Lynn Deary.
That's right, Your Honor.
Well, but these are Alera, it's limited to Alera confidential documents. So if Ms. Deary has received those and then disseminated them, for example, again, we have this email from defendant Ewing to Mrs. Deary attaching the confidential clinical guide. We're entitled to know what she's done with that, because that could be part of the damage Ms. Ewing caused. So I think it is relevant. And if she's got our documents, she shouldn't. And I think we're entitled to know what she's done with them. But particularly in the case of this one, where it comes from one of the defendants to her. We're entitled to explore
So
the damage.
what or who is Elara?
It is now, Great Lakes Carrying does business as Alara Carrying now. And Great Lakes is a Jackson-based company that had a merger with a Texas and East Coast company to form Alara.
Well, if the objection is to producing or any Elara confidential document, I can understand why there would be an objection to that. But if it's an Elara document that relates to any of the defendants, am I missing something here?
No, Your Honor, that's just our point. If it's related to the defendants, or if there are documents that my client disseminated to the defendants, we agree that's relevant and we will produce. But this is much broader than that. It asks for any documents, Alara documents that Ms. Deary has, whether or not related to the defendants.
But what is
That certainly sounds overly broad to me, Mr. Pelton.
But what has she done with those? If she has confidential Alara information, what has she done with it? Where did she get it? We may see that she got something from one of the defendants or used it for the benefit of one of the defendants. And she's tied in. She's a board member of one of the one of these companies we're asking about where they did consulting. She was a board member, actually of two of them, and she's tied to this care line. So she's tied into all of these companies, either as a board member or a family member. And if she's getting confidential Alara information and using it for the benefit of these defendants, or has received it from one of the defendants and caused us further damage by using it at some other company, we would need to know that.
What you just said, Mr. O'Shea has no objection to.
Right. The only thing I have objection to, Your Honor, is if she used it for some other company that has nothing to do with the defendants. How is that relevant to this lawsuit? This again is the fishing part of the expedition, Your Honor. They're trying to find out any information they can about Ms. Deary, whether it's related to this lawsuit or not. And that's what we're trying to limit.
Well, I don't know if Mr. Shea's suggesting that she has such information, but if she has received it from Ms. Ewing, for example, and she uses it at Timbuktu Company, that has caused us damage. We're entitled to know about that because it links back to the defendant. Also, if she has such documents and she's using them for the benefit of the defendants, we're entitled to know that. That's what this is requesting.
I would suggest
if she has Alara documents that she received from the defendants, no matter what she used them for, they ought to be able to ask about that.
Yes.
But if if they weren't received from the defendant,
and used for the benefit,
don't relate to the defendants, what difference does it make for purposes of this lawsuit?
That's what the request asks. I think Mr. O'Shea is reading too much into it, which makes me curious, but
I'm going to limit.
Clearly not.
I'm going to limit if she has Alara documents that she received from the defendants. That's certainly going to be relevant. If she has Alara documents that are related in any way to the defendants, that's fair game for inquiry. But if she has Alara documents from another source that have nothing to do with the defendants, I'm not going to allow that.
Thank you, Your Honor.
Does that adequately address your motion for protective order, Mr. O'Shea?
Yes, it does, Your Honor.
You'll prepare an order to that effect?
We will.
All right. All set for today?
all set.
Yes.
All right, thank you, gentlemen. Have a good day.
Thank you, Your Honor.
So I don't realize you haven't all left yet. Mr. Lindsay, what should I do with this? Just hold it in my chambers, the sealed?
Your Honor, that's fine with me at this point. I suspect it's going to come up at some point in the not too distant future again.
All right. I'll just make sure it doesn't go down to the clerk's office and doesn't somehow get filed.
Yes,
I'll
please
just keep
don't
it in
file it, right?
chambers.
Thank
Okay.
you, Your Honor.
Thank you. Mr. Verana, who should I be expecting to be in this Lewis versus Dan's excavating?
I believe Jessica Bond is the defense counsel for Dan's. They
Okay.
filed the motion.
All right. I just have the docket sheet in front of me and it listed your name and someone by the name of Plato.
Yep, she's that's their firm, and I think we should have Kevin Riddle here. He's in the waiting room,
Okay, I see him. Anyone else?
and then Armenia Duenas.
I see that.
That should be everybody.
All right, and these are all attorneys?
These are two cases
Are any-
consolidated, Your Honor.
All right, and are you expecting any clients that want to participate in the hearing?
I'm not.
No.
Okay, I've got a very full waiting room and I didn't want to exclude anyone. It's always a little frustrating when I get halfway through a hearing and somebody tells me, oh, I think my client's out there. Can you let him in? Okay, this is Lewis versus Dan's Excavating combined with Scott versus Dan's Excavating. And I think we're here on a motion for leave to file amended affirmative defenses. Is that correct?
Yes, that's correct, Your Honor. Jessica Bond on behalf of Dan's Excavating. Yep, this is just Dan's motion for leave to file amended affirmative defenses in both cases. Given the requirement in the court rules that a party must state the facts constituting its affirmative defenses, we're simply moving now to clarify and add facts that have been gathered through discovery thus far. We find that none of the usual reasons for denial of such an amendment are implicated here. And therefore, we're asking the court for leave to amend. I would add that discovery, there's many months left in discovery. We don't close until September 1st. So we're just looking to add facts that have been gathered thus far in discovery to our affirmative defenses.
Is there anyone opposing this motion?
Good morning, Your Honor. Mark Grant appearing on behalf of plaintiff Craig Lewis. I did file a response, Your Honor. I believe the amendments are futile. The three that apply to my client are the wrongful conduct rule or drug use. Defendant, you already listed that as an affirmative defense in their original answer in affirmative defenses, so I don't know why we have to amend that. Secondly, the affirmative defense about my client being previously injured or involved in other accidents. Yes, he's had other accidents. I don't believe he's ever been injured in them, so that amendment is also futile. And then finally, with regard to the spoliation of evidence argument or affirmative defense that defendants wish to add. Your Honor, we preserved the vehicle as long as we could. We even initiated litigation to preserve that vehicle. The state of Michigan destroyed it while the case was pending in the court of claims. I should note that vehicle was available for inspection for defendants for several months after the suit was filed, and defendants, for whatever reason, made no effort to try to inspect the vehicle. Now they're turning around saying that we didn't make it available. We allowed the evidence to spoil. In addition, I believe Attorney Riddles had the vehicle inspected and has made all those inspection reports available to defendants. So any spoliation argument is, I think, in bad faith.
Your Honor.
Hold on, Ms. Bond.
Yeah, Your Honor. Yes. Thank you very much, Judge. Kevin Riddle on behalf of Jalen Scott and the estate of J.V. and Tinsley Johnson. I concur with Mr. Verana's position in his brief, Judge. And just so you know, my expert went out there and scanned the vehicle. You know, they have these electronic scanners that can scan the vehicle. I provided that raw data to the defendant. this particular vehicle, Judge, does not have, it's so old, it does not have what's commonly referred to as black box data that would record significant information. So the issue of their expert inspecting that would be futile because there's nothing to download from the vehicle. So I agree with Mr. Vrana on that issue, Judge. And then I would just say that some of the affirmative defenses are, I don't know that they're really affirmative defenses, Judge. They're kind of repetitive, different variations of failure to state a claim. And so, you know, I know the court's got wide latitude on it, but I just would indicate that I think a lot of these are really not affirmative defenses, Judge.
All right, I'm not going to address the merits of the affirmative defenses. I'm going to grant the motion. You can amend your affirmative defenses. If you have problems with the merits of those defenses, I'm sure I'll hear about them at a future date. Ms. Bond, you'll submit that order?
Thank you, Your Honor. Yep, actually, there was a proposed order attached as Exhibit B
Hold on.
to our
Hold on,
motion. Would you like that submitted under the 7-day rule, or would
If there's a proposed order that I can sign this morning, I'm happy to sign that, but hold on, hold on a minute. Let me see if I can find it. I see, it's your Exhibit B, correct?
Correct. Yep. Yep. The proposed amendments were Exhibit A and Exhibit B.
Any objection to the form of the order, gentlemen?
No, Your Honor.
No, Your Honor.
All right, I'll make sure that that's signed. So, John, what I want you to do is copy this order and just present it to me later and I'll sign it. I don't want to remove it as an exhibit because then we'll no longer know what Exhibit B was in the file. But here's the order. I'll just leave it right on top for you. All right, thank you.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Have a nice weekend, everybody.
You as well.
You too.
All right, Holmes versus Belinsky. And I should be looking for Mr. Kaiser, correct?
Correct, Your Honor. Along with my client, I know Ms. Belinsky is in the waiting room somewhere, should be.
All right. I see Denise Belinsky. Morning, Mr. Kaiser.
Morning, Your Honor.
This is Holmes versus Belinsky. Are you expecting anyone else to participate?
Mr. Holmes is on the Zoom call. I believe his screen name is just his name, Your Honor.
All right, let me look for him. Eric Holmes?
Yes.
Okay. Waiting for both of them to join us. Looks like Mr. Holmes is coming in. I don't know what happened to Ms. Belinsky.
Good morning.
Good morning, Mr. Holmes.
Yes, sir.
Oh, let me try again. I see Ms. Belinsky. Maybe she had signed in twice. The first one I clicked on just disappeared. All right, as soon as we have a connection with her, we will proceed. Okay, I'll be here. I know you will. For a long time.
Yeah, I saw your docket this morning online, Judge. It looks like you have your hands full.
It's a busy one.
Yeah. Hopefully this one will be much simpler and more straightforward than your first few that you've had this morning.
I'm having trouble getting Ms. Belinsky connected.
You wish me to call her, Your Honor?
Probably better if I do that, then I
Okay.
can let her hear and participate in that manner. The only problem is if she's using her phone to try to connect, they usually don't answer their phone.
Well, she called me just a few minutes ago, so I'm assuming, and she was still online then, so.
Oh, we got a connection. Ms. Belinsky, can you hear me? Well, I'm hearing some background noise. I don't know where that's coming from. Ms. Belinsky, can you hear me? Apparently not. Why don't you give me that phone number, please?
Certainly, Your Honor. 313-300-4706.
And if this conference phone is working true to form, it won't go through until the second call. I've had ITT here twice to figure out why it does that, but the first call never goes through, or rarely goes through.
Your call has been forwarded to an automated voice messaging.
I can try, Your Honor.
If you could just text her and tell her to answer her phone when I dial the next time, that would help.
Okay, you got to answer your phone. Did you answer your phone? The judge is trying to call it. Oh, okay. All right. Yeah.
Try again.
The judge calling, so I thank you.
I can't fault her for that. I don't answer calls, the numbers I don't recognize. Ms. Belinsky?
Yes.
This is Judge LaFlamme. I see you're having trouble connecting by Zoom. This works. This will let
Yes, I can see you, but I can't hear you. So.
You probably have your settings off, but let's not worry about it. You can participate by phone.
Okay.
Okay, Mr. Kaiser, I believe this is your motion. Is that correct?
Sorry about that. This is Mr. Holmes' motion for a temporary restraining order and a preliminary injunctive order in the alternative, Your Honor. Essentially what we have here is a trespassing case. Mr. Holmes owns a lot in Michigan Center on Center Lake, and Ms. Belinsky is his neighbor to the north. This is Mr. Holmes' full-time residence, and essentially what's going on here is there's a dispute regarding the boundary line between the two properties. They abut one another, both have lake frontage, and what is going on from Mr. Holmes' perspective is Ms. Belinsky has essentially put her dock completely onto his property. Not only is her dock on his property, it is also obstructing his ability to place his dock and his boat lift on the property that he owns and has riparian rights to. Mr. Trushan has filed a response to Mr. Holmes' complaint indicating that she has some sort of adverse rights to the property because there was a fence row that separated the property over the years, which is true. My client does not dispute that there was a fence row and that fence row was respected as the boundary. The issue is, Your Honor, is that where she's placed her dock at this point in time is by far and away over that line that she's claiming to have some sort of adverse right to. The base of the dock on the shoreline is about 3 to 5 feet past where the fence line used to be, and it extends at an angle further towards Mr. Holmes's property and essentially takes up about a third of his lake frontage. He bought this property. He has 4 small children that he planned on utilizing the property, the lake with this summer. They spent a considerable amount of time last year cleaning up the property, which was the lake itself, and the access to the lake was filled with muck and vegetation and those types of things. And
So,
really,
Mr. Kaiser,
Yes.
Kaiser, let me stop you. It would be helpful to me if you could explain the photographic exhibits attached to your.
and that's what I wanted to get to. I think the one that really explains what's going on here, Your Honor, is Exhibit C.
See, okay, well, hold on a minute. I see, it's a very grainy photograph of what?
This is the
what?
adjacent. These are the 2 adjacent properties.
Hold on. Of what and when?
This photograph was taken prior to the fence being removed this last summer, Your Honor, and it is of the 2 properties. As you can see, there's a line that extends from the bottom of the page that separates the 2 properties, and that is the fence line. There's a shed that runs across there as well. I wish I knew how good of a photograph you have at this point in time, so I could.
I can see a line extending.
That line was the existing fence. It was a split rail fence that divided the properties. And there up in front of it, you can see a dock that extends into the water. That's not at the top of the page, but more towards the middle of the page. That's where Mr. Holmes' dock was.
So that's where his dock was. Hold on. That's where his dock was when? Last season?
Year. Yes.
Okay. And where is, okay, I see Belinsky property and there's a dock there.
That's where her dock was. The only thing that we believe is going on here.
Hold on, Mr. Kaiser. So this year, Ms. Belinsky put her dock in a different place than what's showing on this Exhibit C.
Exactly.
All right. Do you have a picture of that?
There is the survey that is attached to as exhibits F, Your Honor.
Hold on, let me get there. Let me get my bearings.
Are you there, Judge?
I am looking at the survey, but I can't make heads or tails of it with reference to the photograph.
Bottom portion of the survey, Your Honor, where there's the where it's zoomed in, the oval at the bottom, you can see where it says neighbor's dock.
I do see that.
Okay, the property line is above that. which would be to the north, which is the property line separating the two. Where it indicates the neighbor's dock, that's what we would allege is Mr. Holmes's property. And we're also indicating that that's still to the south of where the fence line had existed, Your Honor. There's only a matter of a foot or two between where the survey staked the property line and where the fence line existed. And while my client isn't conceding anything in regards to Ms. Belinsky's adverse claim, he understands and agrees that that fence line has been respected as the boundary line for prior to his ownership of the property. The issue is that even if she's claiming that that's the property line, she's still placed her dock over the property line and extending onto his property.
Okay.
That's the crux of the issue, Your Honor. She's trespassing onto his property. We believe that she's doing so because she was upset that Mr. Holmes removed the split rail fence that was there. But at no point in the past was Ms. Belinsky's dock ever placed in that, even in that general area. Mr. Holmes spent a significant amount of time cleaning up that area so that he could place his dock there and his boat lift there last summer. Like I said, Mr. Holmes lives there year round. That is his primary residence. He has small children that he wishes to enjoy the lake with. Ms. Belinsky has a lake cottage that's not her primary residence. And Mr. Holmes has done quite a bit to improve the area so that it can be used. And we believe it's incredibly clear. I've actually been to the property, Your Honor, and while I realize my testimony to that fact is not really relevant, but if you were to see the property firsthand, her dock is essentially right in the middle of his property, of his beachfront.
So the exhibit E is a picture of the.
That's where his dock was last year in the boat lift.
Oh, that's his dock and boat lift where they were last season. Okay.
And that's essentially where Ms. Belinsky's dock and boat lift, or a dock, is at this point in time.
And what's exhibit D?
That's just, exhibit D is showing the amount of work that's been done to the property to explain to the court how much improvement has been made to that property to remove the vegetation, make it compatible for a dock. Prior to this point in time,
is the fence to the right of exhibit D the fence that was taken down?
Yes, Your Honor.
So the dock that I'm seeing in the middle of exhibit D is actually the defendant's dock at some time in the past.
No, that is the plaintiff's dock last year, Your Honor. And to the right of that would be where the fence line was, and where the alleged property line is, or where Ms. Belinsky alleges that she has her adverse rights to the property. So
well, hold on, because I'm not. I thought the fence was between the two parties' property.
It was until this last summer, Your Honor. Until this.
When it got removed.
Yes.
And you said in exhibit D, that is the fence.
There is no fence in exhibit D, Your Honor.
Oh,
You
what
said
is that
right.
off
I
to the
apologize.
right?
That is, there was, the fence was to the left of where that dock was. I apologize. I misunderstood.
Okay. You totally lost me with that misdirection, Mr.
I
Kaiser.
apologize. No, the
All
right
right.
of that picture is all Mr. Holmes' property. There's no dispute in regards to that.
Okay. All right. I think I understand your position. Let me hear from Mr. Trushin.
Thank you, Your Honor. I'm looking at this, if this is what you've been looking at.
No,
Okay.
I haven't seen that yet.
This was attached to our answer, Your Honor.
Let me see if I can find it. Not
I
seeing
can
it.
approach the bench with this.
You may approach.
The shed area, and I can approach to point it out again, is also, according to their survey, on my on supposedly on part of their client's property.
Do you know when this aerial photograph was taken? I see a date of 5/4/21. That's probably when it was printed.
I would think that's when it was printed, Your Honor. I know they update those, I believe, every 6 months.
Oh, okay.
So what our basic concern is, number one, my clients own the property since 2002. She has been that fee owner, again, for 19 years. The fence row has always been, with predecessors and up until including this last year, has always been the memorialization of the lot line.
So the fence does show up in this drawing near the bottom?
Yes, and it goes the whole length of the property to the water, Judge. We've indicated that, in fact, again, that has always been the memorialization of the lot line between the parties in regard to that. Up until Mr. Holmes had it surveyed, obviously this is beginning to be the issue. If I can address the TRO first. The TRO is obviously an equitable action to say, stop and continue the status quo. We're talking about a boat lift and a boat for each one of these folks. We're not talking about a home. We're not talking about somebody in immediate issue with something. We're not talking about irreparable harm. There should have been pled if in fact, but there's no facts and circumstances to it. To ask for a TRO from this court would indicate that in fact the status quo somehow would harm one or both of the parties. There's no irreparable harm, Judge. They're likely, they have to prove they are likely to.
How do you give them back their summer on the lake?
Judge, I have an answer to that, and I've discussed it with Mr. Kaiser. I will skip right to that if you like. I would indicate to the court, Judge, we've answered all their questions in my answer in response to their request for TRO. It's in writing. I would stand behind that, but I have an answer. And what I said, Judge, was this. Mr. Kaiser, your client just moves over 10 feet to stay away from the lot line. My client will agree to move her dock in that, to leave us that 10 to 15 feet in regard to it. We're having another survey done to indicate exactly where that line is. We were going to use the same people, Judge, that they used. However, when we discussed that with those folks, they indicated that would be a conflict to now be hired by the adjoining landlord. I understand that. So, Judge, to edify to you, we have contacted and retained another firm to come out there and shoot that line in regard to exactly where it's at. Mr. Kaiser and I had discussion in regard to it, saying we just moved, even if the judge only says each one of you move 5 feet away from that alleged fence line in regard to that until we get a good survey and go from there. Mr. Kaiser has indicated to me that in fact that was not a problem. However, later on we learned that in fact it was a problem, that his client did not want to in fact move his boat at this time, even if it's only 5 to 10 feet. My client will be more than happy to do that, to give us an area until they finally get that there.
So I was under the impression that because of where the defendant's dock is, that Mr. Holmes wasn't even able to put his dock in. Is that incorrect, Mr. Kaiser?
He's not able to put his boat lift in at this point in time, which goes adjacent to his dock. Your Honor, the issue is, and I think that Mr. Trushin somewhat misrepresents our conversation about the potential settlement. I did not agree to anything. I told him I would have to speak to my client. And after I spoke to my client, he indicated that that area where he cleaned up the dock, where he cleaned up the shoreline, is where he had placed his dock in the previous year and where he has placed his boat lift in the previous year. And when he puts his boat lift in, it is quite an undertaking. And to have to move it again later at some point in time. And what's frustrating to Mr. Holmes, Your Honor, is that we agree that the fence line is the respective boundary line. The surveyor shot the line, and that survey basically indicates that the fence line is the boundary line, Your Honor. Her dock is some 3 to 4 feet on the shoreline across from where the fence line used to be, and then goes towards Mr. Holmes's property, goes at an angle towards his property. So essentially takes up about 25 to 30 feet of his actual shoreline, his ability. And he has anywhere, his lot is 66 feet wide, and he has approximately 100 feet of shoreline. When she's 30 feet over, that takes up a considerable amount. And on top of that, Your Honor, that's the area that he had his dock and boat lift last year. She's doing this out of spite, Your Honor. That's our claim, is that she's upset that he removed the fence. And in order to punish him for that, she's now placed her dock across the line. And that, Your Honor, is there's just no reason for it. She's never placed her dock there in the past. You can look at all the GIS images from the last 15 years, and her dock is always to the north of the property. Mr. Holmes's dock is on his property line and over from where that fence line used to be. And because of that, Your Honor, I would agree. I mean, I would state that that is irreparable harm. He has 4 young children. They go tubing, things like that in the lake. He purchased this house with that intention, and he's going to lose Memorial Day weekend. He's going to lose potentially the 4th of July, and there's no reason for it. It does her no harm whatsoever.
Here's what I'm going to do. Here's what I'm going to do. I think the best status quo is the status quo that existed last summer. I'm ordering the defendant to move her dock to wherever it was last year, and I'm ordering that Mr. Holmes may place his dock and boat lift where they were placed last year. I realize there's probably not the best markings on the ground for what that is. Make your very best efforts to put them in the same place, and we'll leave to another day determining where the actual boundary line is and what may happen in the future.
Your Honor, I would suggest one thing: the fence, the holes from the fence posts are still there, and so it's very clear where the fence was at one point in time. I would just suggest that both parties remain on their respective side of the fence post. So.
My order is very clearly put it back where it was last summer, and I expect good faith on both parties' part. If I find that somebody moved it significantly from where it was last summer, there could be repercussions for that. I realize you probably can't get it exactly where it was. I'm just looking for good faith placement, and I'm not going to make any reference to boundary line or fence line. Put it back where it was last summer. Leave it there until further order of the court.
I can prepare that order, Mr. Kaiser.
Okay, thank you, Mr. Tricia.
Judge, I just want my client to I want her to understand that she's to do exactly what you've indicated, to place the boat and boat lift on her part back to where it was last year. Do you understand that, Ms. Belinsky?
Yes, can I have a couple of weeks to do that? Because I'm going to have a problem getting someone to move the dock at this point.
That's up to the judge.
I'll give you 7 days to do it, ma'am.
Okay.
Thank you.
Have a good day, everyone. This many people would fit in my waiting room. I think you just asked if I signed a judgment. I didn't.
You didn't yet? Okay.
I saw it sitting on the end of the bench. I can do that now if you like.
Okay. Judge, that'd be great.
That way you won't have to come back. How's that? Not that I don't
I told him I like
enjoy seeing you.
I like him. I'll stop in one day and we'll talk.
Sounds good. Yeah, this is probably not the day.
I see that.
Good morning, Mr. Grand. I was looking through your paperwork for the name of the individual who wants me to approve this.
Your Honor, it's Leanne Wellman. It's my understanding she's in the waiting room too.
All right, let me find her. It's right on the very end of the counter. Boy, there are a lot of people in here. They're probably all wondering what I'm doing.
Busy day.
It is. Unfortunately, I have a lot of people that are here by iPhone, telephone number. They don't, I'm pretty sure this is in my Zoom instructions to put your name in the screen.
It does.
And
you know,
people don't do that.
No,
It's not that hard.
It's not, but especially people who are not very familiar with Zoom, you know, by this point, all of us attorneys have figured it out. But some of the people who don't do it very frequently have not quite gotten it mastered.
$21st today?
Yeah, I believe it is, Judge.
Just the JOD, there's no, DOK, of course there's not. There you go.
Thank you, Judge.
And have a good day, Captain.
I told you, John. Shannon, take care.
Have a good one, George. See you soon.
And I'm sorry, Mr. Grant, tell me again. Okay, Leanne Wellman, I finally found it on the last page on your proof of service. And I'm pretty sure there's no Leanne. Let me go through and make sure. So what I'm going to have to do is go to each of these individual phone numbers and find out who they are. And hopefully she's one of them. At least this will save me having to do this the next time I'm looking for somebody who should be here.
Yeah, and as
Telephone number ending in 8397. What is your name, please? All right, whoever this is, you are not coming through. I'm going to remove you. You're going to have to try again to connect. All right, we'll try again. Telephone ending in 0430. What is your name? (0430). I just let you into my courtroom. What is your name? You just heard something. Can you hear me? Can you tell me your name, please? Looks like that same one. You're going to have to try for a better connection. I cannot hear you. And I see that same number in again. I'm going to remove it again. I don't know who that was. What, a very bad connection or nonverbal? One or the other, I guess. Okay, I've got an iPhone. Let's see who that is. iPhone 4071. What is your name?
Me?
You.
Hi, this is Cassandra Rose.
All right, Ms. Rose, I'm going to put a name on your screen so I know who you are. And then I'm going to put you back in the waiting room until we're ready for you, okay?
Okay.
I have an iPad. Let's see who's there. And I'm having trouble making an audio connection with this one. I've got a few people logged in with just a first name. Sometimes the first name happens to be a boyfriend's phone or a child's phone. I really not sure I want to wade through all of those first name ones if there isn't at least her name somewhere on it. Still waiting on the iPad. Do you happen to have a telephone number for this?
I do have a phone number, but I don't think she's calling in from the phone number that she had. It was my understanding that my client had arranged for somebody a notary to go and set up the Zoom connection, which I don't know.
Could be under a notary's name.
Correct. Could be under somebody else's name. I was gonna if you want to put me back in the waiting room for a moment, I will give her a call and try and make sure that they're still in the waiting room, and to find out how it's listed if it's not listed under her name, and tell them to change the name. I know one of the issues people run into, because I've occasionally had it, is that when you get the chance to rename yourself just before you commit to joining the meeting. Once you've joined the meeting and you're sitting in the waiting room, the only way to rename yourself is if you go into like the advanced, audio settings, which is kind of, not, it's not intuitive that to check on your name or to correct your name, you would need to go into, what appears to be unrelated settings. But once you get in there, then there's all the settings available.
Okay, Mr. Grant, I'll put you back in the waiting room and hopefully bring you back in shortly.
I will hopefully to be back.
Your Honor, out of curiosity, can you chat the whole group in the waiting room?
I don't think so. I can do that with breakout rooms.
Okay, but not in the waiting room?
I don't think so. I've never seen a setting that allows me to do that. And based on what he's just telling me, it might be a waste of time anyway if it's that hard to change the screen name once you're already in there.
I don't think it is.
It's easy. I can change it myself easily.
I think you just have to right click on your name when you're in Zoom, and then you can just type in.
I always thought, that's the way I do it. But anyway. All right, let me see what I got. So we'll come back to that one. All right, Hawley versus Creech. Good morning, Mr. Hilderly.
Good morning, Judge.
This is a matter of Hawley versus Creech. Who else should I be looking for in my waiting room?
Justin Hawley should be on there.
Find him.
And then the attorney for Miss Creech is David Cobb.
I have a Justin. Is that the right Justin?
It is.
Okay, and you're not expecting anyone else?
Yeah, the attorney for the defendant is David Cobb.
Right, you told me that one already, and I've got him in.
Yeah, I'm sorry, nobody else.
Okay, this is a matter of Hawley versus Creech Kemplin. We have Mr. Hilderly for the plaintiff and Mr. David Cobb for the defendant, and we're here on a motion to approve a settlement, correct, Mr. Hilderly?
That's correct, Your Honor.
All right, Mr. Justin Hawley, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down, state your full name for the record, please.
Justin Lee Hawley.
Go ahead, Mr. Hilderly.
Thank you, Your Honor. Mr. Hawley, you are the father of Andrew Jack Hawley, correct?
Correct.
And he goes by Drew, correct?
That's correct.
And Drew was involved with an incident where he was attacked by a dog on or about September 28th, 2020, correct?
Correct.
That attack happened at 545 South Detman Road here in the city of Jackson, county of Jackson, state of Michigan, correct?
Correct.
As a result of the attack, Drew suffered injuries, correct?
Correct.
Could you describe the nature of the injuries for the judge and also the treatment that Drew has received because of those injuries?
Yeah, he was attacked by the dog in 3 different areas. He was bit on the chest, where he had puncture wounds and bruising that it lasted probably about 7 or 8 months before the bruising went away. Attacked on the chin and the forehead, both required plastic surgery. About 400 stitches total to put the chin and the forehead back together. So we had one about 7-hour plastic surgery at U of M Motts, and then several follow-up appointments, and he had to have pretty much around the clock care because of his autism and some of his sensory issues. He had a lot of difficulty with the incisions and the stitching.
Okay. And as a result of those surgeries, does he have scarring?
He certainly does, yes.
And as you mentioned, Drew is disabled, correct?
Correct.
And we've provided a letter to the court which outlines the disabilities that he suffered from.
Correct.
As a result of this dog attack, we filed a claim in this matter against the homeowner of where the dog was, correct?
Correct.
And we've been provided with a declaration sheet showing that the policy limits for the insurance policy covering that house is $100,000, correct?
Yes.
And we have agreed to resolve the case for the policy limits of $100,000, correct?
Yes.
And you understand that we could pursue this claim further in court. We could achieve a better result, a worse result, or the same result, correct?
Yes.
And you also understand that because of the policy limits, we could receive a result in excess of $100,000, but that amount may be uncollectible, correct?
Correct.
And knowing all of that, you've decided that it's in Drew's best interest to resolve this matter for the policy limits of $100,000, correct?
Correct.
And as a result of Drew's disabilities, does he receive governmental assistance and benefits?
He does.
And the settlement proceeds from this case would disqualify him from receiving those governmental benefits, correct?
Correct.
And both now and in the future, correct?
Correct.
And as a result of that, or because of that, the funds will be placed in a special needs trust for Drew's benefit, correct?
Yes.
Thank you, Judge. Those are all the questions I have.
Mr. Cobb, did you have any questions of Mr. Hawley?
I do, Your Honor, just a few. You understand that this would be a full, final, and complete settlement of any claims that you would have against the parties that you claim, that either you or Drew would have against the parties that you claim to be responsible for this matter?
Yes.
Okay. And Do you understand that Drew would have up to 1 year after his 18th birthday in which to bring a claim on his own behalf, but by settling today, you're waiving that right for him?
Correct.
Okay. No other questions.
I'm satisfied based upon the proofs and based upon the availability of funds. Clearly, these were severe injuries and likely would bring a greater reward than policy limits. On the other hand, collecting beyond policy limits is a sad reality of our situation. I believe it is in Drew's best interest that I approve this settlement, and I will approve it. Mr. Kilderly, will you submit an order to that effect?
I will, Your Honor. Thank you.
Thank you, everyone.
Thank you.
Have a good day. Have a
Thank
good
you,
day,
Your
Mr.
Honor.
Hawley. Mr. Grand, did you make any headway?
I did. I spoke with Ms. Wellman and the notary who's there with her. They jumped out and then jumped back in, said that they had renamed it. If it's not under Wellman and they're having a problem with the new name sticking, it's possible that it would be under Dusenberry. That being the notary.
It's under Wellman, and I just clicked on it.
Okay, thank you.
Good morning. This is a matter of transfer of structured settlement proceeds. You are Ms. Wellman, correct?
Yes, sir.
All right, Ms. Wellman, I'm going to ask you to raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand down. I need you to state your full name for the record.
It's Leanne S. Wellman.
Thank you. Go ahead, Mr. Grand.
Thank you, Your Honor. Mrs. Wellman is proposing to sell to my client 48 monthly payments of $224.03 each, beginning on August 10th, 2021 and ending on July 10th, 2025, followed by 184 monthly life contingent payments of $224.03 each, beginning on August 10th, 2025 and ending on November 10th, 2040. If Your Honor finds this transaction in the best interest of Mrs. Wellman and her husband, she will receive $11,200, which is an effective annual discount rate of 24.92% per annum. Would the court care for some more testimony from Mrs. Wellman?
No, I am fine.
Well, I'd like to understand what steps she took to explore this and whether she tried other avenues to realize this this cash other than simply through J.G. Wentworth. So let me ask you, Ms. Wellman, do you realize that the effective discount rate here is almost 25%? That would be equivalent to you going out and borrowing money at the rate of 25%, which is an extremely high rate. I mean, most credit cards don't even go that high. Have you tried? Have you investigated any other companies who buy structured settlements? This is an extremely high discount rate. Based on what I've seen recently, the last one I did, I saw one under 10%. I saw one at around 14%. I haven't seen 24.92%. If ever, it was several years ago. So what all did you do to try to explore this other than talking to J.G. Wentworth?
I went to the credit union that I have been doing business with since 1985, and they turned me down. And I went to American One Credit Union, and they turned me down for a loan to get this stuff done. And I've went to another credit union. I can't think of the name, sir. I'm sorry. And
So why do you need to access this money now rather than just wait for the payments to come through?
because my payments went down from $1,500 or $1,559.04 to $1,074.03. And if I was getting that $1,500, I would be able to do what I want to do to the house, but I can't because, you know, I got bills to pay and stuff like that. And my husband can't work because of his heart.
So you want to use this money to make improvements to your home?
Yes, sir.
So my question is, I know obviously you spoke to the company that Mr. Grand represents this morning, JG Wentworth. Do you know that there are other companies who buy structured settlements? Have you talked to any other ones?
No, sir. This is the only one that I have seen on TV that I thought that I could go through.
How urgent is your need to make these repairs to your home?
As soon as possible.
Are we talking about roof repairs or repairing plumbing, things that make the house livable, or are these just things to improve the appearance and
it's to improve the appearance.
So, ma'am, do you have access to the internet? Do you have a computer?
No.
Do you have transportation that you could go to the public library and use a computer there?
Yes, sir.
What I would like you to do, and they have people at the library that will help you with the computer, is to go to the library and search for structured settlement purchases, something like that. They can help you with the search. I'd like you to check with a couple of other companies. The rate that this company is offering you is extremely high. I suspect you can find another company that's willing to buy this from you for a much lower discount rate, and that means you would receive a lot more than just $11,200.
Okay, sir.
So here's what I'm going to do. I'm going to simply adjourn your hearing. Let's put it out 28 days, and Mr. Grand, I would want you to renotice it.
Your Honor.
I want you to, when you come back, I'm going to ask you whether or not you were able to find anyone else. If you find someone else, just tell JG Wentworth that you're no longer interested in doing this transaction and sign up with somebody new. I think you can do much better than 24.92%. Okay?
Your Honor,
Yes.
I had spoken with my client yesterday because based on some of our prior cases, I thought that there may be that the amount may be a little bit low, and my client can do better and is willing to pay in exchange for the same payments, increase the payout to Ms. Wellman to $17,800, which would bring the interest rate down, effective interest rate down to 19.7% per annum. The court should note that the bulk of these payments are life contingent payments. So if Mrs. Wellman does not survive through 2040, at which point, by my calculation, she'd be 75. My client will obviously not receive any of the money that was scheduled to be due if she passes away.
So give me the amount, the dollar amount again.
Correct. My client could increase the payout to 17,800.
And that discount rate is
19.7% per annum.
So, Ms. Wellman, even though that rate would be high for maybe some other person who didn't have a life contingent survival. In other words, you don't get all of these payments unless you live and survive to when the last one is due. That justifies a higher discount rate because J.G. Wentworth takes the risk that you could pass away tomorrow, and they've essentially handed over all this money and they're not going to be able to collect on the structured settlement. The 19.07% under that scenario, I think is much more fair. So I've told you to go out and do this research, but based on what I've heard today, I would not require you to do that research if you find these adjusted terms acceptable. Do you find them acceptable?
Yes, sir, I do.
All right, I will approve the purchase of the structured settlement for the sum of $17,800 at a discount rate of 19.07%. Mr. Grand, if you,
I just want to make sure the record's good. It's 19.7%, not 0.07.
I'm sorry, I wrote down 07. 19.7%. Thank you. And I will sign that order upon its presentment, Mr. Grand.
Thank you, and I'll make the corrections to the order and get that over to your clerk shortly.
Thank you, Mr. Grand. Ms. Wellman, I don't know how long it takes for that to happen, but I feel much better about the amount that you'll be receiving for this. So you do want me to approve it, correct?
Yeah.
You're welcome. You're welcome, ma'am. You have a good day. Mr. Grand, good to see you.
Thank you. Have a great day, Your Honor.
That's the first time I've ever had that happen. I'll explain later. Okay, let's see. Is this next? No, this one's next. Jennings. So, Mr. Jennings, you're here on the Rendell matter?
Yes, Your Honor.
All right, let me find. Let's see who filed this response.
Javon Williams.
Javon Williams. There he is. Are you expecting anyone else?
No, Your Honor.
Good morning, Mr. Williams. This is a matter of Rendell versus Jackson Crossing et al. Mr. Jennings is present in person. Were you expecting a client to participate?
No, Your Honor.
Okay, and this is plaintiff's motion to compel more complete initial disclosures. And I see that you filed a response to that. Mr. Jennings, I'm assuming you've seen the response. Do you have a response to the response? I'm trying to cut to the chase a little quicker. I've got a lot of people still waiting to get my attention this morning.
Sure, and I can cut to the chase. There's a couple items that under the court rules, I believe, should have been produced with initial disclosures. Number one, Mr. Williams has indicated that the insurance coverage and policy information would be produced under separate cover. I still don't have that information. All I have is that the limits are $1 million. I'm entitled to the policy. I'm entitled to the deck page. It hasn't been produced. The defendants have an obligation to produce electronically stored information. The defendants in this case have produced photographs from the date of the incident, but haven't produced them in an electronically stored fashion. Although in their answers to requests for productions, they've indicated that they still have them on an iPhone. I'm entitled to those in electronically stored fashion. The initial disclosures also mentioned other non-parties who may be at fault, but there's no documentation or mention of who those people may be. So there has to be some sort of proffer. You can't just say somebody else is at fault. And as a final point,
If they don't identify somebody else at fault, you don't need to worry about that affirmative defense.
fair enough, Your Honor. And the final one is the issue of the security footage or surveillance footage from the date of loss. The defendants have produced a portion of video footage from Bed Bath & Beyond. However, what they purport that video to show is different than what it actually shows, which leads me to believe that they have more than one version of this security footage that they haven't produced. For instance, the security footage has, it's from inside the Bed Bath & Beyond, so it's not in the whole hallway. The responses to requests for production of documents mentioned that this video footage clearly shows the caution when wet signs are out in place. It's impossible for that to be the case. And they say that it shows that clearly, and that's why they have no liability for this loss. Well, if they saw footage that shows that, I'm entitled to that footage as well.
Well, in terms of video footage, whatever you've got, you have to produce. There's no question about that. You obviously can't produce what you don't have, but if there's video footage as requested, it needs to be produced. Mr. Williams, are you aware of some video footage that has not been produced?
Absolutely not, Your Honor. And frankly, may I respond to the motion in total at this time?
Did you cover everything, Mr. Jennings?
Yes.
Okay. Yes, you may.
Your Honor, I'm sorry that we have to be here for this matter. A few things. Initial disclosures are filed at the outset of a case based on information known at that time. We filed initial disclosures. We've answered plaintiff's discovery. I believe that plaintiff's attorney may not have reviewed the discovery responses or even the response to this motion. I believe that a copy of the insurance declaration sheet was attached to this motion, to the response to this motion. If not, it should have been. But we disclosed the limits for certain in the initial disclosures. We're not hiding the ball there, Judge. As you just indicated, we cannot produce what we don't have. With respect to the photographs that were taken at the scene, plaintiff's counsel wants these photos in some electronically stored format. We've advised that the photos were taken with an iPhone 7, the date that they were taken, and who took the photos. That's what we can produce with the initial disclosures. It's at the outset and the written discovery phase. We've given him that. With regard to the surveillance from Bed Bath & Beyond, number one, I don't represent Bed Bath & Beyond in this case. We did reach out to them to ask if they had any video of the incident. They produced the video that they've had. I received that, immediately forwarded a copy over to plaintiff's counsel. We even put plaintiff's counsel in touch, in communication with the corporate representative from Bed Bath & Beyond. That individual told him, I'm on the email thread, Judge. We've produced everything that we have. We understand that you want video from the entire day. We don't have it. It doesn't exist. My office cannot produce or manufacture evidence that does not exist. He may not like Bed Bath & Beyond's response. Take it up with them, subpoena them, take a dep of someone over there. I don't control them. All I could do is facilitate that conversation, which is what we did here. This motion is to compel more complete initial disclosures. We have no obligation to fully litigate the case at the initial disclosure stage. We've answered written discovery. We've produced the anticipated areas of expert discovery. We didn't file a notice of non-party at fault that was vague that would lead him to file a motion to strike the notice of non-party at fault. We're very early in this case. I don't know what the plaintiff's testimony is going to be with respect to someone else that walked in this area immediately before her, whether someone spilled a drink. We don't know. We don't know. But to ask the court to compel more complete initial disclosures when we've produced everything that we have is ridiculous.
So, Mr. Jennings, did you, in your discovery requests, ask for these specific items that you've delineated this morning?
Yes, Your Honor. As part of the discovery, we requested the full insurance policy, and Mr. Williams gave the same response that it will be produced under separate cover. That's something that's absolutely in the defendant's possession, and that was in the possession of the defendant.
That one's easy. Produce the policy, produce the deck sheet.
And I think the other thing, the surveillance issue, maybe it's just another motion for another day on the issue of different versions, different copies of it, and I'd be happy to do that.
If they've already produced all that they've got, they can't do any better than that. If Bed Bath & Beyond's got more, you need to be subpoenaing that from Bed Bath & Beyond, not from Jackson Crossing.
And then in terms of the photograph, if they have electronically stored information, they have to produce it.
All right, and that one's easy. Clearly, you can forward a digital version from an iPhone. Whether or not you were obligated to do that on the initial disclosure really doesn't even matter to me today. What matters is if you've got an iPhone with digital photos on, you need to forward the digital photos.
The photos that they already have, Judge, because they're in possession of the photos.
He wants the digital version of the photo, and he's entitled to them. Not just the photograph, but the digitized version that resides on this iPhone. I want that produced. Okay?
I'm on board with that, Judge, but is this, I'm not trying to be difficult here, but is the individual that took the photo with the iPhone 7, assuming that it's still on that iPhone, because it's my understanding that plaintiff's counsel has had this for some time, is he just supposed to email it? How are we doing this?
Yeah, you can email them. You can attach digitized photos from a phone. You can also, there's other ways you can transfer them. How you do it, I really don't care. But the photos that were produced need to be produced in digital format. Whatever manner of doing that is easier for you, I'm fine with, but it needs to be in digital format.
Fair enough.
And I understand why, because you can do things with a digital photograph that you can't do with the plain photograph. You can increase the resolution, that sort of thing. That's a reasonable request.
Fair enough, Judge.
Is 14 days work for you, Mr. Williams?
Yeah, I mean, assuming that he still has it on the iPhone 7, it should be pretty quick, but 14 days, sure. You want to put that in an order?
Right. Yes, you can put that in your order.
Thank you.
All right. Thank you, gentlemen. Have a good day.
Weekend.
Thank you.
Hey, I've made it to the 9 o'clocks.
Yeah. We're
cooking.
We're really rocking and
We
rolling.
are cooking. That's just, I'm still on page 1.
I know it.
All right, let's see. If I can find these names. So I don't have. The plaintiff's lawyer listed. Let's see Mr. Schumacher. Don't see Mr. Millstone. I don't see Mr. Bodwin. Oh, yes, I do. Let's get him in. He can tell me who else is supposed to be here. Okay, Mr. Bodwin, looks like we've got a connection.
Yeah.
Who else should I be looking for on the Lot versus City of Jackson matter?
I think just Mr. Schumacher.
I didn't see him on the first pass through. Is there someone else from his firm that you've been dealing with as well?
No, and he and I have been emailing all morning. So I know he's there and he's been waiting.
Well, let me try again. I went through the list twice now.
I can send him a quick email.
If he's logged in, he's not logged in under his name. It's Kevin Schumacher you're dealing with?
Yes.
Let me try one more time. There's still a lot of people in there, and I could have passed it over. There's somebody signed in under Kevin.
Gotta be him.
Let me see. Let me see if this is the right one. It is.
Passed it over.
Mr. Schumacher, good morning.
Good morning, Judge. Are you able to hear me?
I can just fine. Let me give you a little tip. When you log into a court's waiting room, make sure you put your full name there. We had trouble finding you. Okay. This is Lot versus City of Jackson. And let's see, what are you here on? A motion to quash a writ of garnishment. I'm guessing, Mr. Schumacher, that's your motion.
When you log into a court, it's my motion, Your Honor.
Oh, okay.
Trouble finding you. Oh,
go ahead.
May I proceed? I'll be very quick.
Please do.
Okay, Your Honor, Randy Podwin, I represent a craft agency. A craft agency is an insurance agency. It is not an insurance company. The plaintiff obtained a default judgment against Woody's Logging for $750,000. The plaintiff then applied for a writ of garnishment against the craft agency, which the court issued February 1st of this year. But the problem, Your Honor, is, and as I pointed out in my motion, there is absolutely nothing that the craft agency had at that point in time, had in the past, or will have in the future that is in any way related to Woody's property, assets, anything. It's nothing. All craft does is procure insurance policies. It's not like a bank. It's not like a financial institution. It has zero. So our position is that when the writ was issued, there was no basis to issue it. Now, since the writ was issued, Woody's has filed a separate errors and omissions claim against the craft agency for allegedly not turning in the lot claim. But Your Honor, this is a mere expectancy. I will be defending this particular lawsuit, but the claim belongs to Woody's. It doesn't belong to Kraft. Kraft doesn't own it. Kraft doesn't control it. Kraft will defend it. Kraft has insurance. The insurance, they have a $2 million limit. The insurance will pay any judgment or settlement if that happens, which Kraft says or believes is highly unlikely. But the bottom line is Kraft doesn't have anything that shouldn't have been issued. We request that it be quashed.
I never did a whole lot of collection stuff as an attorney, and I don't see a lot of collection stuff in circuit court. They get a lot more of that downstairs. But I was under the impression you get a writ of garnishment served on you. You file a disclosure that says you don't have any assets or you don't have anything that's available to garnish. I thought that ended the process. Why is there a necessity to quash something at this point?
Our position is, Your Honor, the writ is still out there. It's in effect until, I don't know, until August or something. There's no basis for it. We don't have anything. We filed our disclosures, and the disclosure said we don't have anything. Mr. Schumacher then sent out interrogatories to which we responded. He then sent us a subpoena for our complete agency file. I sent him everything electronically, thousands of pages. When does this end? There is no basis for this writ in the first place.
Mr. Schumacher?
Thank you, Your Honor, and I can appreciate the court's perhaps lack of experience in collection. We have, on any given day at our firm, 5,000 to 7,000 open collection files. Without patting myself on the back, I do a lot of garnishments and I'm pretty familiar with the rule, which is MCR 3.101, and I did cite that. And, the only part of my brief that I really want the court to, focus on, because, I'm not taking factual issue with almost anything Mr. Bodwin said in his motion, except for his conclusion is to quash it, okay? Factually, he's got it pretty spot on in terms of judgment entered, garnishment issued, disclosure. The way the disclosure statute or the garnishment statute works is I serve a garnishment. The garnishment turns me into a plaintiff again, only this time my defendant is the garnishee defendant. The garnishment itself serves as the complaint. The disclosure filed by the garnishee defendant, Mr. Bodwin's client, serves as the answer. Once I get that disclosure under 3.101, I have 14 days to challenge it. If I don't challenge it, I'm done. And that's what usually happens. That's 99% of the time. It says, hey, we got no assets, we walk away. All right. However, if I challenge it, I have two ways to challenge it. I can send interrogatories within 14 days, which I did. And I can set up a deposition, which I would say I also did by doing the subpoena, documents only deposition. And they complied. They produced the documents. And if the court goes to 3.101 sub M sub 1, 3.101 sub M sub 1, if there is a dispute regarding the garnishee's liability, the issue shall be tried in the same manner as other civil actions. Okay, that's the gravamen of where we're at right now. In my conversations with Mr. Bodwin, and I mean, he's a consummate attorney, and I mean, we've had great conversations and stuff. I mean, we just take issue with, which way this court goes next. My position is I dispute their disclosure that they don't owe anything. This isn't garnishing an employee's wages. We don't think that the principal defendant Woody's was ever employed there. We think the Kraft agency owes money to Woody's. All right. And the court rule provides for that. And I've cited that in my brief, and that if you look at 3.101 sub B sub 2, Non-periodic garnishments, which is what we have here, are garnishments of property or obligations other than periodic payments. We believe that the Kraft agency dropped the ball on its obligation to Woody's. And our basis for that is really quite simple. Woody's got sued, Woody's got served. After Woody's got served, Woody, I can't remember his first name, the principal of Woody's logging company, said he called up his agent, and then the agent instructed him to take it over to the agency and we'll take care of it. Woody's has signed a verified affidavit saying that's exactly what he did in this new lawsuit that has been filed. All of the relevant facts are now 2 years old because all of this happened before I garnished the Kraft agency. This is literally a claim by Woody's against the Kraft agency for an errors and omissions situation. Kraft agency dropped the ball, told Woody's he was okay. Woody relied. Kraft agency did not forward the lawsuit onto the carrier so that the carrier would provide a defense and indemnity. All right, so Woody's has now sued, and there's another lawsuit in your court. John Gormley is the attorney on that one, representing the plaintiff in that case, Woody's. And just so the court understands, my position is we send a court officer out to Woody's to seize his assets. All right, and this court issued an execution. We sent court officer Michael Ramsey out there. He went out to seize, and he was told by Woody's, hey, I turned that over to the insurance company. Perhaps a little bit inarticulate. I turned it over to the insurance agency, and they said they were going to turn it over to the carrier for me. I've got insurance for this because all of this stems from a contract that Woody's has with the city of Jackson. You can't be a contractor with the city of Jackson to trim trees unless you have proof of insurance. When we looked at it, there's proof of insurance showing that the Kraft agency was the generating agency and that there's XYZ carrier, that should be on the hook for any liability that is proven against Woody's. So Woody's thought they had coverage, took it to their agency. Agency gives them the thumbs up, you're okay, don't worry about it, we got this covered, we do this all the time. And this wasn't the first time Woody's had been sued. Woody's had followed this procedure with the Kraft agency before. They're long-term customer client of the agency, all right? So, I'm in a position where I can actually, by execution, seize anything that Woody's has by execution. I call it execution, Judge, perhaps older, order to seize property.
So, but what you're seizing at this point, if you're correct, is the claim, the unliquidated claim against the Kraft agency. There really isn't anything else to seize at this point until that claim becomes liquidated. Is that right?
We are waiting for liquidation to occur in the other suit or in this suit. I could technically proceed on the claim in this case to establish the liability. All right. Now, therein starts generating a bit of a conflict of interest. Ms. Lott, as plaintiff, has a $750,000 judgment against Woody's. If Ms. Lott seizes all of Woody's assets, including a claim against Woody's insurance company, Ms. Lott, what am I going to do? Am I going to start talking to Woody's and I say, Woody's, tell me exactly what happened? There starts to become a conflict of interest there of me representing Woody's and Ms. Lott at the same time as I'm going after the agency / insurance company situation.
So from your position, the writ shouldn't be quashed, but there's nothing to collect until that underlying claim is resolved in terms of actually collecting dollars.
That's correct, Your Honor. And if you look at MCR 3.101 sub M as in Mary 6, 3.101 M as in Mary sub 6.
I'm there.
If the court determines that the garnishee, that's a Kraft agency, is indebted to the defendant, but the time for payment has not arrived, a judgment may not be issued or entered until after the time of maturity stated in the verdict or finding. And that's kind of where we're at, okay? But what I don't want...
Essentially what happens then is this garnishment stays open until such time as that maturity occurs, or there's ultimately a finding that there's no liability.
that's why I don't want it quashed, Your Honor. But, if you look at my wherefore clause at the end of my brief, it says, I would think it beneficial to consolidate this action with the other action. Just, I've known John Gormley for about 10 years, and it's the same factual issue.
Is that really necessary, or do we simply, because this is post-judgment, I'm not worried about something remaining open for a substantial period of time. Is it really necessary to consolidate? Can't we just sit tight on this one and ultimately wait and see what happens with the related case?
I'm perfectly content sitting tight in this case, Your Honor. I may file a motion to intervene in the other case just because, my concern is that between an insured and his insurance company and the question of should we make funds available for Miss Lott to garnish, I want to make sure that is vigorously advocated. And again, this is not impugning Mr. Gormley. I've litigated against him.
I understand your position. Mr. Bodwin, any more to say about this?
Nothing really, Your Honor, except for the fact that ME writ was issued. There was no lawsuit. The lawsuit was filed 2 months later.
But whether there was a lawsuit, there still was a claim. Well, the claim arose when the insurance company breached its, or the insurance agency breached its obligation to submit the claim to the insurance company, if they did. So even though it's an unliquidated claim, the fact that the lawsuit got filed later, I don't think makes any difference.
I certainly don't want to litigate the errors and omissions claim. You can imagine I'll be taking a position of defending it.
Doesn't sound like Mr. Schumacher wants to litigate it either, but he just wants to make sure it is vigorously litigated. I'm going to deny the motion to quash. Mr. Schumacher, you'll prepare that order?
Yes, I will, and I'll submit it under the 7-day rule, Your Honor. Thank you.
Okay.
And Mr. Schumacher, thank you for the education on garnishments.
Thank you, Your Honor.
Hopefully I'll remember it if it ever happens again.
All right. Thank you.
Thank you.
Have a good day, sir. Good morning, Ms. Reynolds.
Good morning, Judge. How are you?
I am well. Who else should I be looking for in this case?
Mike Stevenson.
All right, let me locate him in this long list of.
Oh, I can't even imagine what your day's been like. My goodness.
I think I've got 3 days worth of motion hearings scheduled for a half day. So,
that's what it sounded like.
all right, I found Mr. Stevenson.
Okay.
I thought you were gone, and I'm looking at our dockets on Fridays. I'm like, you were here, so I don't.
Mr. Stevenson, good morning.
Morning.
Are either of you expecting anyone else to participate?
No.
No.
All right, I'm going to take a very short break since I've been out here steady since 8:30, but I'll be right back. Shannon, you can take us off the record. I'm just going to leave the live stream going, so be careful what you say.
Okay.
Very good.
Okay.
This is crazy, man. Fridays are not like this, just so you know.
I don't really mind it. I just am doing those orders.
Have you?
Yeah.
Okay, Shannon, you can put us back on.
Go ahead, Judge.
I decided while I was gone to brew another cup of coffee too, so sorry for the little extra delay.
No problem.
Okay, this is Clark versus Jackson Radiology Consultants, and this is a motion in limine by the defendant.
Correct, Your Honor.
Go ahead, Mr. Stevenson.
So to refresh your recollection here, this is a failure to diagnose breast cancer case between a mammogram done in 2016 and a mammogram done in December 2017. Now, in the briefs, it's somewhat confusing because this was done in December. The cancer was diagnosed in January, and so you're going to see throughout the briefs there's some confusion whether we're talking about 2016 and 2017 or 2017 and 2018. We're all talking about the same thing. So I just want to kind of clarify that for the court. So the difference, the question is, would there have been chemotherapy if this had been diagnosed a year earlier? That is the question that we're trying to figure out here today, and whether there's any evidence to suggest that. We attached an affidavit from the treating oncologist. That's Dr. Trimble. And in his affidavit, he indicates that he would have given chemotherapy even if the diagnosis hadn't been a year earlier. And so the basis of determining whether or not there's going to be chemotherapy is the age of the patient, which is a patient who's under 60 years old, and a thing called the recurrence score. And that's really what we're here to talk about, is the recurrence score. So there's a new procedure, relatively new procedure. When you have a tumor, you can do, it's called an oncotype RX. And what you do is you look at 21 genes of the cancer, and then you score the cancer on its likelihood that it is going to recur. If the recurrence score is 26 or above, then chemotherapy is given. If the recurrence score is under 26, it may or may not be given. And so the question we have in this case, we know the recurrence score was 26 when the cancer was diagnosed in 2018. The question is, what would the recurrence score have been if it had been diagnosed a year earlier in 2017? And so our position is there's no reliable evidence to suggest that it would have been anything less. Now, the plaintiff's expert uses what's referred to as a nomogram. So to have an oncotype RX done, it's a very expensive genetic analysis. And so in order to help decide whether you're going to run an oncotype or not, some nomograms have been created. They're not widely used, and in fact, neither Dr. Trimble nor my expert has ever even heard of the Tennessee nomogram used by Dr. Pennington. And so what's key, though, is a nomogram is never used to determine what the RS score actually is. The nomogram is used only to determine whether or not you're going to run an oncotype to determine what the RS score is. And so it would be completely unreliable to use it for any other purpose, nor has the plaintiff presented any evidence to suggest that a nomogram is used to actually determine whether or not chemotherapy is given. It's used only to determine whether or not it's worth it to have an oncotype done to determine the RS score. So if we go to this case, we ran this case through the nomogram using the evidence of what, the factors for 2017 and the factors for 2018. So the factors for 2017 indicate that there's only a 9% chance using the nomogram that you will have a recurrence score above 26. And so what that would mean then, if you were a physician, is you might consider not running the oncotype because the percentage is so low. But when the same thing is run in 2018, you get a percentage of 10%. So the difference is 9% to 10%. But what's key here is there's a range of statistical error. And so the statistical error for 2017 was between 7.8% and 9.9%. And in 2018, 9.2% to 11.8%. You don't have to remember those numbers, but all you have to do is realize they're overlapping. And so from a statistical standpoint, there is no evidence to suggest using the nomogram, which is not used for this purposes, but even if you use it for the purposes, statistically, there's no difference as to whether or not this would or would not have been an RS score of 26. So that we also know that the RS score, the nomogram is not reliable because in this case, we know in 2018 that the oncotype was done. And that's key for a couple of reasons. First of all, Dr. Trimble didn't use a nomogram. He just went ahead and ordered the oncotype because that's what most oncologists do. And the oncotype showed a recurrence score of 26. That is despite the fact that the nomogram would suggest that there was only a 10% chance of it being 26 or higher. And so that shows you how unreliable the nomograms are and why they're not used to determine recurrence scores. Again, they're used only to determine whether or not you should run the oncotype test. And so then that takes us to plaintiff's expert, Dr. Pennington. So Dr. Pennington, first of all, when he ran the nomogram, he used the wrong information. I think the plaintiff has conceded that. It's interesting that in his affidavit, he doesn't even acknowledge that he's used the wrong information in the nomogram. And when he used the wrong information, the difference was between 1% and 10%. But I think the plaintiff will concede using the correct information, you're talking 9% to 10%, but with overlapping statistics, so it's a tie. And so I think that's a key to Dr. Pennington's, one of the keys to his mistakes. All right, so the question then, is there other supporting evidence for Dr. Pennington's opinion? Now he's suggesting based upon what he thought at the time was 9%, which we know at this point is statistically a tie, that he can say somehow that the RS score would be less than 26 a year earlier. If you look at page 9 of our brief, at the very top, the question that's asked Dr. Pennington was, are you aware of any studies that would suggest that the change in oncotype within a 12-month time period? And so when we look at a Daubert standard, the question is there anything to support his opinion that the oncotype would have changed in a 12-month period? Because that's his opinion. And his answer is no, I don't think those are available. I actually called Exact Sciences, those are the people that do the oncotype testing, and tried to find out that question or answered that question, and they were not able to tell me. And so what you have here is it's his bare opinion that using this nomogram, that's a statistical tie, that the RS score would be lower. And he readily admits there's absolutely no evidence other than his own opinion to support that. The plaintiffs attached numerous articles to indicate that cells mutate. Nobody argues that cells don't mutate. But the question here is, within that 12-month time period, is there evidence that the cells would mutate to the extent that the RS score would be different? And you can look at every single article the plaintiff attached. They're just generic articles that say cells mutate. That's basic science. Nobody really, it doesn't make any difference. So those are the facts we have. If we go to the law, you can look at page 14 of our brief. That is where we lay out the statutory requirements to have reliable evidence. If you look at 629.55A, it's whether the opinion and its basis have been subjected to scientific testing and replication. There's absolutely no evidence that they have. Again, the nomogram is used to predict the RS score, but not actually it's used to determine whether or not you're going to get an oncotype, but it doesn't predict what the score actually is. And again, it's cited in our brief, Dr. Pennington's testimony is, if you think it's going to be different a year earlier, what would it have been? And his answer is, I don't know. He doesn't know because there's no scientific evidence would allow him to make that kind of determination. So if we go to B, whether the opinion and its basis have been subjected to peer review publication. I just read you that quote from Dr. Pennington where he answers no. Then we go to C, the existence and maintenance of generally accepted standards governing the application and interpretation of a methodology or technique, and whether the opinion and its basis are consistent with those standards. Well, he did it wrong. So no, his opinion is not within the methodology or those standards. We go to the next one, which is D, the known or potential error rate of the opinion and its basis. Well, we have the error rate, which I showed you in my brief. It's a statistical tie. And so you can't say from a statistical standpoint that the 1 year made a difference. And so again, it shows you that the opinion here is unreliable. And then we go to E, whether it's generally accepted within the relevant expert community. We provided you with 2 affidavits that indicate that people don't use the nomogram to determine the RS score. If you look at the nomogram actually attached to my brief and to the plaintiff's brief, it also indicates that it's not used to determine the actual RS score. There's no evidence to the contrary. Therefore, it is not used or generally accepted for the purpose that Dr. Pennington is trying to use it. Then we go to F, whether the basis for the opinion is reliable and whether experts in the field would rely upon the same basis to reach the same type of opinion being offered. There's absolutely no evidence that anyone other than Dr. Pennington would use the nomogram to predict what a RS score would be a year earlier. There's not a single peer review article. There's not a single non-repair article. There's nothing in this case whatsoever. And the last one you have is G, whether the opinion or methodology is relied upon by experts outside the context of litigation. And that's the same as F. You have no evidence that it was. And what the key here is the plaintiff has the burden of proving that Dr. Pennington's opinion on this point is reliable. None of the factors have been met. The opinion that somehow you can use a nomogram to guess what the RS score would be a year earlier is simply not reliable. And by his own admission, there's no support for it in the literature. As a result, that opinion has to be stricken.
So Dr. Pennington's, ultimate opinion is that there was a delay in diagnosis that led to harm to the plaintiff, essentially.
His opinion, on a grand scale, yes. We're just striking the opinion.
And that's what I'm asking, just on a grand scale. And is Dr. Pennington the only expert for the plaintiff that's going to testify that the delay resulted in harm to this plaintiff?
Yes.
Yes.
So this is the only expert. If I grant your motion, plaintiff's case is over.
It's summary disposition, yes.
So,
Not possibly, Mike, you know it is.
Well, arguably, I would like to take that as an admission, but the plaintiff could argue that knowing she had cancer a year earlier, caused some other damages, psychological or otherwise. But as far as damages resulting from chemotherapy, the answer would be, yeah, that would end that portion of the plaintiff's case, which is the bulk of the damages claimed.
Just for clarification purposes, we have a radiology expert as well as Defendant Parik's own colleague who admits the cancer was there a year earlier. It's clearly identified a year earlier. There can be no argument in this case that there was not cancer there a year earlier. The only question is when it was diagnosed in January 2018, following her December 2017 mammogram, at that point, when it was diagnosed, it was stage 1. It was only 1.8 centimeters in size, and it had metastasized. There was only one. She had 3 lymph nodes removed at that time. Only 1 had a micrometastasis. So the important thing is that in all the case law that defense counsel cited, mind you, Dr. Appel was the expert in all of those, but really what they deal with is when there's a delay in diagnosis of cancer, when it's found, like in one of the cases, it was lung cancer that had 16 lymph nodes involved. Well, to say there was 1 year earlier, there would have been no lymph nodes involved. Judge, I don't know how much you know about cancer or not, that if, depending on the size of the tumor when it's found, and if there's any lymph node involvement, that's how you determine whether or not you need chemotherapy or not.
Funny, because no expert here has testified to that, and that's not in the affidavit of Pennington. And in fact, I quoted, that's just the opposite, where he says, you don't look to metastasis, recurrence score is what you look at. So
Mike, I
you
didn't
can
interrupt
testify
you.
to that,
You
but I can
would
show
me
you
the same.
in the brief
hold
where he
on.
says that.
It's not even an issue
Save
here
that
because
for your reply.
there was only one
Please do not interrupt.
micrometastasis. So there's no question that had it been found the year earlier, there would not have been any lymph node involvement. So Dr. Penn, so the opinion that defense counsel strike.
Hold on a minute. So if it had been detected, apparently it was detected, but it wasn't read. It existed in the prior, but nobody picked up on it.
Correct. Defense counsel, sorry.
How would the treatment have differed if it had been detected a year earlier?
She still would have required surgery, and she still would have required radiation. She would not have required chemotherapy. So that's the big issue in this case, is that Sharon Clark suffered devastating injuries. Every complication you can imagine, she suffered as a result of the chemo. Because of that, that's why they're trying to strike my expert's opinion that had it been diagnosed the year earlier, she would not have needed chemo. Now so Dr. Trimble did recommend that she receive chemo when it was diagnosed because she had an oncotype score of 26. So even based on the size of her tumor and the micrometastasis, he even told her 99% chance you're not going to need chemo. When that oncotype score came back as a 26, which is the cutoff. If it had been 25, he wouldn't have recommended chemo. She had an oncotype score of 26. It goes from 0 to 100. Because she had an oncotype score of 26, he recommended chemo. So Dr. Pennington's opinion was, had it been diagnosed the year before, it is more likely than not her oncotype score would have been less than 26, and therefore chemo would not have been recommended. The premise of defense counsel's argument is that because oncotype score is based on genetics, it won't ever change. So if it was 26 in 2018, it would have been 26 the year earlier. So that was the big reason on why there was so much literature attached about how cells even become cancer. That I don't have cancer now, I might next year. It's because my genes can mutate and I can develop cancer. That's how cancer actually develops to begin with. So to say that an oncotype score is 26 now, and 3 years from now, it'll still be 26 is ridiculous. Interestingly enough, I was playing around with the nomogram, and Judge, you can even pull it up. You just Google University of Tennessee breast cancer nomogram, and you can keep all the factors the exact same. There's only 5 things that you plug into it because it's already based on only breast cancer, only that's ER positive and ER2 or HER2 positive. So the only thing you're looking at is the estrogen or the progesterone. But so when you put everything else in the same and you only change the size of the tumor, the oncotype predictor score changes. Well, if cancer didn't mutate, then that wouldn't ever change. So size alone, because that's what Dr. Pennington explained, is that a cell starts as normal, and then it mutates into cancer. And then as it grows, it mutates farther. And that's how your cancer becomes worse. That's how you go from stage 0 or 1 to stage 4, how your tumor grade increases. That's how then it metastasizes. Your cancer gets worse. Everybody knows the earlier the diagnosis, the better the prognosis. And what they're trying to say is that, doesn't matter. She was diagnosed the year earlier, nothing would have changed. And we all know that's not true. So frankly, the reverse motion will be coming to strike the testimony and opinions of Dr. Trimble and Dr. Appel. So just very quickly, Judge, the their arguments are, one, that the nomogram is junk science. No, it's not. It was actually, if you read Exhibit B, Mr. Stevenson was completely wrong. Nomograms are not only used to decide whether or not to use to run the oncotype test. They're actually used because socioeconomic factors, not everybody can afford a $4,000 oncotype. So to allow, what the oncotype score does is it allows the treaters to decide on whether or not to recommend chemotherapy. Will it be beneficial? So they're able to put the patient's information into his oncotype. So without running this $4,000 test, they can use this as guidance on whether or not to recommend chemotherapy for their patients or not. It is not junk science that in Exhibit B, Dr. Trimble provided the nomogram, and there's also on the site that he provided, it has a list of, it was 39 articles on which this is based. This is not junk science. It is a test that has been performed on something like 86,000 patients through the cancer database. This is a very reliable and scientifically based publication, and it is based on peer-reviewed articles and extensive research. Now, there is no way to say so when Dr. Pennington admitted, I can't tell you exactly what it would have been had it been diagnosed following her 2016 mammogram. You can't. How the oncotype score is even done, you take, after your surgery, so after her tumor was removed, they then take from pathology, send this to Exact Sciences and run it. So it's done on the actual tissue. So obviously no tissue was taken in 2016, and there's no way to study it to see if it changes, because once the cancer is removed and you run the oncotype, it's not growing in the body anymore. So you then can't, nor would you ever ask a patient to, we're going to leave the cancer in your body and see how it reacts, year after year after year. You physically can't do that because it's run on the pathology. So once you remove it, it's gone. So you can't, there's no way to have articles or scientific evidence. It simply is not even possible because it's run on pathology after the surgery, after your cancer's already removed from your body. So you can't go back and retest it. So he indicated also that, so the nomogram is not based on junk science, and that's established. Then he claimed that Dr. Pennington used incorrect data. Well, his opinion was more likely than not, had her cancer been diagnosed after the 2016 mammogram, more likely than not, she would not have needed chemotherapy because her oncotype score would have been less than 26. So
let me ask you, when they did remove the tumor and they determined that at least one lymph node was involved.
A micrometastasis, yeah.
Right. There was something in a lymph node.
Mm-hmm.
A year after the cancer first appeared on a mammogram or whatever it is it showed up on, do you need all these fancy calculations and theories for a cancer doctor to say, if it was that tiny a year later, it probably wasn't there a year earlier?
Agreed, Judge, but I agree with you on a personal level, and I think any juror is going to understand that. However, I do think that with the requirements for medical malpractice cases, I think we do need an expert to say that. Do you have to have the oncotype score? Keep in mind, 10 years, the oncotype score only really started to be used in 2011.
Sorry, here's what I'm getting at, okay? You got an oncologist expert who's treated patients, and he has the opinion that, yeah, if you had a micrometastasis, whatever it was,
metastasis, yeah,
in a lymph node, a year later than the cancer first appeared, and you didn't find it anywhere else, that it's highly probable that this micrometastasis occurred sometime after that first failure to diagnose.
Doesn't have
And
that
if it
opinion.
hadn't, well, that's
part of his
yeah.
opinion.
So,
Page 6 of my brief, there's a quote asking him that very question. And he says, I can read the quote. It's so if this
Hold on,
patient had a
let me go there.
micrometastasis, so I asked him point blank, if this patient had a micrometastasis with a tumor of 1.9 without relation to oncotype, would you or would you not have recommended chemotherapy?
No, okay,
And
Mike,
you're suggesting the
mischaracterizing his
answer is
testimony.
that it would be yes,
That is
Judge.
it.
And what he actually says is,
okay,
I would not have
but-
made any decision until I had the oncotype. The oncotype is the deal breaker. And so nowhere in his opinions, and she can't show you any part of his testimony where he says, based upon the finding of micrometastasis a year earlier, therefore there would not have been chemotherapy. I'm sorry, yeah. Just because he found micrometastasis in 2018, there's no testimony where he was going to say, based upon that, there would not have been chemotherapy a year earlier. That's
Because
nowhere.
you didn't ask him that at his discovery only deposition.
You provided an affidavit. Where is it?
The question that you
Hold
just cited,
on,
Mike, is
hold on
from
a minute.
what you
Hold
asked
on a
regarding
minute.
when it was diagnosed.
Hold on a minute. Maybe I missed something here. So the micrometastasis in this lymph node did in fact show up in the year earlier
No.
X-ray, but it wasn't detected.
No.
So the all right.
You can only determine micrometastasis from pathology. You can't determine it from radiology. Because there was no biopsy a year earlier, it may or may not have existed a year earlier.
No, that is his opinion. So even before oncotype, you look at.
Okay, so hold on. If there hadn't been a micrometastasis detected, there wouldn't have been chemotherapy in this case. Is that
Incorrect.
fair?
No.
How is that wrong? Help me understand.
Based upon the oncotype of 26, that was the decision that there would be chemotherapy. If with or without micrometastasis.
Wait a minute. So the oncotype isn't in part dependent upon whether or not there's a micrometastasis?
No.
Yes and no. Keep in mind, the oncotype is part of the genetics. So as the cancer grows and mutates more, the oncotype score is going to be higher. So when it was diagnosed, it was twice the size as it was the year earlier. It now had a micrometastasis. So yes, the oncotype score was 26, which is literally the cutoff of when you need chemotherapy. So
I mean, perhaps we need a Daubert hearing so we can bring our experts in and have them tell you, so it's just not us telling you. But you can have any cancer can metastasize, whether it's an oncotype really low or an oncotype high. The higher the oncotype, the more likely it is to metastasize, but they're not one and the same.
Well, it's going to metastasize as it grows, and had you diagnosed
All
it
right,
the year before.
let me say this. I am not comfortable ruling either way on this based on what I've heard so far, and I'm out of time. I would certainly consider a Daubert hearing at some point so that maybe I can understand this better, and that would make me be a better gatekeeper. But I'm having trouble processing this based on my very layman, rudimentary understanding of cancer and how it spreads. I'm having trouble processing this and putting it into that context. At a very basic level, it just seems so painfully obvious to me that if she didn't have involvement of her lymph nodes when this was first discovered, she probably wouldn't have had chemotherapy.
And that
because
is
because it was involved her lymph nodes, and there's been a beginning of some kind of metastasis, there's a greater risk. If you find it there, it could be somewhere else. Let's be sure. let's give her chemo. But you're telling me, no, they don't, that's not based on that at all.
Correct.
Mr. Stevenson's telling you that, not the experts.
It takes years for metastasis to form, so it can take, you can have cancer now and it wouldn't be diagnosed for 5, 6, 7 years.
Can I quote you on that, Mike? If you're saying if it takes years to metastasize, then she for sure wouldn't have had it into the year before.
Hang on. So if you let me explain that point. So what you do then, Judge, is they look at the genes of the cancer to determine, okay, what is the likelihood that this may have already metastasized or is going to metastasize? And that's the recurrence score. How likely is it to recur? Meaning, if you cut it out, it's going to recur somewhere else. That means that's the recurrence score. So with or without metastasis, it's the recurrence score.
Okay, and I'm out of time. I clearly need to understand this better in order to rule on it. If you think that could be better accomplished with a Daubert hearing, where I actually hear from experts, I would be amenable to that. And that's something we could do, even though I can't schedule a jury trial now. That's something I could do.
If we're going to do that, I'm going to ask that Appel and Trimble both appear as well.
They're the ones that are going to testify that Pennington doesn't know what he's talking about. So absolutely, they'll support their affidavit.
I can't wait to cross-examine them on their opinions that genes don't change.
All right. And I'm assuming because you just got their affidavits, Ms. Reynolds, you haven't had a chance to depose them yet?
Nope, and I'd like to.
I would think absolutely, since Mr. Stevenson's relying on those affidavits in part for his, essentially, this is going to be the plaintiff's case. If I bar this expert, there's not much left, if anything.
And Judge, how will we handle, because even Dr. Trimble, although he was a plaintiff's treating oncologist, he won't respond to me, so I doubt he'll even appear for a subpoena. And it's not, and Mr. Stevenson's going to claim he doesn't have control over him because he's not his employee. So I'm not sure how we're going to handle taking Dr.
You can compel his appearance by subpoena. And if his attorney wants to challenge that, there's an avenue for him to do it. But otherwise, I expect him to be responsive to a subpoena.
Okay.
All right. So
so holding this in abeyance until further discovery.
I'm not ruling on the motion today.
Okay.
You can do your discovery. Make arrangements for when you're ready to do this Daubert hearing. And that's probably where we're going to end up, folks. I think with the experts, I'll be able better to understand what the issue here and whether or not I can say, as Mr. Stevenson says, that Dr. Pennington is blowing smoke and I can't possibly let this guy testify to this stuff in front of a jury.
Very good.
Sounds
okay,
good.
Thank you.
Thank you
for your patience this morning.
Thank you. All right. Have a good day.
Have a good day. Say, as Mr. Stevenson says, that Dr. Pennington is this guy.
Yeah.
All right, whoever's got their YouTube playing, please turn it off. It sounds like several of you do. I just let everyone in. I'm going to try to wait till I have an audio connection with everyone. It looks like there's a few more still trying to connect. All right, I don't see any of those little squiggly lines, so I'm assuming everyone is here. I am leaving now for the morning. I will be back at 2 o'clock. If you are unable to have your hearing continued at 2 o'clock, make arrangements for having it adjourned. Otherwise, I'll take up the remainder of my morning docket at 2 o'clock. Thank you.
Does that include Richard Peterson?
It includes everything that was on my morning docket.
Okay, thank you, sir.
Thank you, Your Honor.
Thank you.